Gildan Media, a division of Recorded Books, presents The U.S. Constitution for Dummies by Dr. Michael Arnhem, narrated by the author. So, let's get started. Chapter 1. Identifying the main principles and controversies of the Constitution. Most of the stuff written about the Constitution is boring and hard to understand. But it doesn't have to be. And frankly, it shouldn't be. Because the Constitution is pretty important. Yes, important to you in your daily life. In this book, I do my best to explain the Constitution in simple language. That's why the series is called For Dummies. It doesn't mean it's for people who are ignorant. It just means it's easier to follow and understand. And in this chapter, I offer a broad introduction to the Constitution, what it is, who created it, the principles it does and doesn't discuss, and the areas of controversy that keep it in the headlines even today. So, what do we mean exactly by a constitution? Okay, here goes. A constitution is a sort of super law that regulates the way a country or state is run. How helpful is that as a definition? Not very? Okay, so let's be more specific. And this time let's focus specifically on the Constitution of the United States. The U.S. Constitution is the supreme law of the nation, controlling the following main features, plus a few more. First, the functions and powers of the different branches of the government, the President, the Congress, and the courts. Secondly, the way in which the President and the Congress are elected and how federal judges are appointed. Third, the way government officials, including the President and the judges, can be fired. And fourthly, the relationship between the federal government and the states. And last but not least, your rights as a citizen or inhabitant of the United States. Now, the word Constitution can mean either the physical paper document or constitutional law, as defined by the U.S. Supreme Court, which includes a number of features that don't actually figure in the document itself, such as the rights to privacy, abortion, and gay marriage. These additional features are mainly a product of the so-called living Constitution approach to the Constitution as a document, which believes that the Constitution needs to be constantly reinterpreted to take account of changes in prevailing social, political, and moral values. On the other hand, strict constructionists, textualists, and originalists interpret the Constitution as a document, sticking closely to the perceived original meaning of the words in question. I discuss the different approaches to constitutional interpretation in Chapter 3. Let's have a look at knowing when and why the Constitution was created. The Constitution emerged from a meeting called the Philadelphia Convention, which took place in 1787. That meeting has since come to be known also as the Constitutional Convention. The convention was held because the Articles of Confederation, the document that had been serving as the country's first governing constitution, were considered to be weak and problematic. Say more about that in Chapter 2. The stated goal of the convention was to revise the Articles of Confederation, but the outcome was much more than a mere revision. It was a new form of government. The 55 delegates to the Philadelphia Convention came to be known as the framers of the Constitution. They represented 12 of the 13 states. Rhode Island didn't send a delegate. And they included some familiar names such as George Washington, Alexander Hamilton, and James Madison. The convention lasted from May 25th to September 17, 1787. In the end, only 39 of the 55 delegates actually signed the Constitution. 3 delegates refused to sign it, and the rest had left the convention before the signing took place. For the Constitution to take effect, it had to be ratified or confirmed by 9 states. Special conventions were summoned in each state, and the Delaware, New Jersey, and Georgia conventions ratified the Constitution unanimously. But some of the other states saw a pretty fierce battle for ratification. In New York, for example, the Constitution was ratified by only 30 to 27 votes. Ratification was achieved in 1788, and the Constitution took effect with the swearing-in of President George Washington and Vice President John Adams on April 30th, 1789. Now, just a word to distinguish the founders from the framers. The term Founding Fathers was probably coined by President Warren G. Harding about 100 years ago, much later than the Constitution itself. Founding Fathers, or simply Founders, refers to the political leaders of the struggle for American independence against Great Britain. It includes the American leaders in the Revolutionary War, the signatories of the Declaration of Independence, and also the framers of the Constitution, or simply the framers. The founders include George Washington, Benjamin Franklin, Alexander Hamilton, John Jay, John Adams, Thomas Jefferson, James Madison, James Monroe, Patrick Henry, and Tom Paine. The term Founding Fathers overlaps somewhat with the term Framers of the Constitution, but the two terms are not identical in meaning. The term Founders is much broader than the term Framers because it covers all the leaders in the fight for American independence, including all the delegates to the Philadelphia Convention who drafted the Constitution. So all the framers were founders, but not all the founders were framers. Thomas Jefferson, for example, drafted the Declaration of Independence and was one of the leading founders of the United States, but he was not involved in the drafting of the Constitution because he was on official business in France at the time. So Jefferson was a very prominent founder, but he was not a framer. Now, let me just summarize the main principles of the Constitution. In broad strokes, here are the principles you find in the Constitution. First, liberty. The framers of the Constitution aimed to establish a form of government that gave the people as much individual freedom as possible by guaranteeing them religious freedom, freedom of speech, and freedom to defend themselves with arms. Second principle, federalism. The United States started out as 13 separate British colonies, which banded together to throw off the British yoke. At first, in 1777, the colonies formed a loose alliance under the so-called Articles of Confederation, not to be confused with the similarly named Confederacy proclaimed by the seceding Southern states in the 1860s. But the need for a stronger central government resulted in the drafting of the U.S. Constitution, which was ratified in its original unamended form in 1788. The Constitution established a federal system of government, which gave the central or federal government certain clearly defined and limited powers, reserving the remaining powers to the states or to the people. Third principle, separation of powers. The framers of the Constitution were very anxious to prevent any one person or institution from becoming too powerful. So the Constitution keeps the three branches of government separate, These branches are the executive, that is the President, the legislative branch, which is Congress, and the judicial branch, which is the law courts. But a system of checks and balances, as it's called, cuts across this separation. So, for example, Congress passes laws, but the President can veto them. Similarly, the President has the power to appoint cabinet officers and federal judges, but his appointments are subject to the, quote, advice and consent, unquote, of the Senate. And the Supreme Court can check any perceived abuse of the power of Congress by striking down laws that the court rules are unconstitutional. Fourth principle is due process. Due process of law is one of the main buzz phrases of the Constitution, according to the Supreme Court. You may assume that this phrase would refer simply to procedure, or how things should be done, like whether or not you are allowed a jury trial. But the Supreme Court has widened its interpretation of the phrase greatly to include substantive due process, or what rights the Constitution actually confers or protects substantive due process. As a result, the Court has interpreted the Constitution as guaranteeing a bunch of controversial fundamental rights, including an expansion of the rights of those suspected or accused of crimes, an expansion of minority rights, privacy, and abortion. Here are some of the principles you may assume are addressed in the Constitution, but actually aren't. Democracy, for example. The words democracy and democratic don't figure anywhere in the text of the Constitution. In its original form, the Constitution was not democratic, and the House of Representatives was the only directly elected part of the federal government. The Constitution became democratic as a result of the rise of President Andrew Jackson's Democratic Party in the 1830s. More about that in Chapter 6. Equality. This is another of the principles that actually do not figure in the Constitution as such. Equality is not mentioned in the Constitution in its original form. Slavery formed an integral part of the Constitution until the Civil War. For example, Article 4, Section 2, Clause 3, provided in its original unamended form that runaway slaves who escaped from a slave state to a free state had to be delivered up, that's the phrase used, delivered up, to their original owners. The whole structure of the House of Representatives also depended on slavery. In its original form, Article 1, Section 2 of the Constitution apportioned the representation of the various states according to the numbers of their free population plus 3/5 of their slaves. This 3/5 rule cynically used the slave population, who of course did not have the right to vote, to give the slave states more representation in the House of Representatives than they would otherwise have had. Women didn't have the right to vote in the U.S. as a whole until 1920, though some states had allowed women to vote before then. To this day, the interpretation of the Anti-Discrimination or Equal Treatment Amendments to the Constitution remains highly controversial. The most controversial amendment is the 14th, which can be invoked either in support of affirmative action or in opposition to it. Those Supreme Court justices who support affirmative action see it as a necessary part of the anti-discriminatory thrust of the Due Process Clause of the 14th Amendment, while those justices who oppose affirmative action see it as itself just another form of discrimination. And just a word about the Federalist Papers. When the U.S. Constitution emerged from the Philadelphia Convention, after being signed by delegates from each of the 12 participating states, it still had to be ratified or confirmed by the states, each of which summoned a special convention for this purpose. Fierce controversy reigned. In October 1787, Alexander Hamilton, a leading member of the convention and a dedicated upholder of the Constitution, started publishing a series of articles explaining and justifying the Constitution. Hamilton got James Madison, another leading convention delegate, to join him. John Jay, another founding father, although not a convention delegate, also contributed some articles. The series of articles was titled The Federalist and was described as, quote, a collection of essays written in favor of the new Constitution, unquote. Hamilton himself wrote 51 of the 85 articles, Madison contributed 27, and Jay wrote 5. Although they were written before the Constitution took effect, these essays show tremendous insight into the problems of government and have been cited ever since as embodying an authoritative interpretation of the Constitution. Now, let's identify a few areas of controversy. The whole text of the Constitution takes up just a few pages of print. So why do you need to read a book this long, or to listen to a book this long, in order to understand it? The old-fashioned language of the Constitution sometimes needs to be explained, and there are a few, actually surprisingly few, genuine ambiguities in the text. But for the most part, you can blame it on the lawyers and the judges, particularly the U.S. Supreme Court, who have made a major production out of a pretty simple, straightforward document. How come there's such major disagreement about what the Constitution means? There are essentially 3 reasons. First of all, old-fashioned language. The English language has changed since the horse and buggy era, when most of the Constitution was written, but perhaps not as much as you may think. Consider the following examples. Article 3, Section 2 contains the phrase aid and comfort in connection with committing treason. Does this mean that you go to jail if you give the enemy milk and cookies? Not quite. The phrase was lifted straight out of the Old English Treason Act of 1351. The word comfort comes from a Latin root meaning to strengthen. So giving the enemy aid and comfort really means actively assisting the enemy and strengthening him, whether by means of arms, money, or intelligence. The biggest changes have occurred in punctuation. So, for example, the Fifth Amendment ends with this prohibition, quote, nor shall private property be taken for public use, comma, without just compensation, unquote. Some commentators have claimed to notice a smudge in the original handwritten version of the Bill of Rights, which they take to be a comma between taken and for, making for public use a bracketed phrase. They conclude from this that the Constitution allows the government to take private property for purposes other than for public use. Even if there's meant to be an additional comma in there, this interpretation is plainly wrong. First, in the 18th century, commas were strewn around much more liberally than today, without affecting the meaning. Second, the idea that the government can just take private property whenever it feels like it goes clean against the whole tone and tenor of the Constitution. What about ambiguity? There are a few passages in the Constitution where the meaning is genuinely in doubt. Here are two examples. First, do individuals have the right, quote, to keep and bear arms, unquote? The Supreme Court says yes, but the wording of the Second Amendment is not at all clear. I discuss this important question in chapters 12 and 15. Another ambiguity. If the president dies, does the vice president become president or only acting president? Article 2, Section 1 of the Constitution is genuinely ambiguous. The 25th Amendment, which came along only in 1967, says that in these circumstances the VP does become president. But the problem was actually solved in practice by John Tyler back in 1841. See chapters 10 and 22 for all the details. Another area of ambiguity is to do with interpretation. Many of the disputes about the meaning of the Constitution arise out of different approaches to constitutional interpretations by justices of the Supreme Court. Here are a couple of the most controversial constitutional issues. First of all, can Congress pass any laws it likes? The Supreme Court says no, but some commentators disagree with this interpretation and read Article 1, Section 8 of the Constitution very widely. In particular, they interpret the power of Congress to, quote, pay the debts and provide for the common defense and general welfare of the United States, unquote, as meaning that Congress can pass any laws it likes. This reading is almost certainly wrong, and James Madison said so himself. I tackle this question particularly in Chapter 9. Another one, does the President have the power to lock up enemy combatants, as they're called, enemy combatants, and deny them access to the U.S. courts? In the 2008 case, Boumediene against Bush, by a majority of 5-4, the U.S. Supreme Court said no. However, in June 2012, the court declined, without comment, to take up appeals filed on behalf of 7 Guantanamo detainees who claimed that they had not had a, quote, meaningful opportunity, unquote, to challenge their detention. Another important question, is the death penalty kosher? Yes, but it does depend on the method used. Lethal injection is now the favored method, and the Supreme Court says it's not, quote, cruel and unusual punishment, unquote. But the Supreme Court has also held that it's unconstitutional to execute minors and the mentally ill. In a case called Glossip against Gross in 2015, the Supreme Court held by a majority of 5-4 that the use of the drug midazolam was not unconstitutional. Justice Breyer used his dissent to launch an attack on the constitutionality of capital punishment of any kind. Welcome to Groundhog Day, was Justice Scalia's sarcastic response, referring to earlier attacks on capital punishment in cases such as Furman v. Georgia, 1972, in which a 5-4 majority succeeded in temporarily banning the death penalty as unconstitutional. In April 2017, the Supreme Court was again confronted with a problem with midazolam, which its manufacturers were no longer prepared to supply for the purpose of execution. The state of Arkansas was anxious to execute a number of death row inmates before its stock of midazolam reached its expiration date. Newly appointed Justice Neil Gorsuch formed part of the 5-4 majority, allowing all but one of the executions to go ahead. Can a school district assign students to public high schools on the basis of race alone? In 2007, by 5 votes to 4, the Supreme Court said no. Writing for the majority, Chief Justice John Roberts held that, quote, the way to stop discrimination on the basis of race is to stop discriminating on the basis of race, unquote. Why, then, we may ask, do school districts in a number of states still require parents to fill out a form asking, quote, what race or races do you consider your child, unquote? The form often lists more than 50 races to choose from. The short answer to the question is simply that the school districts concerned have not yet reached the goal of a colourblind educational policy. Is gay marriage constitutional? Marriage doesn't figure in the U.S. Constitution at all. It was considered to be a matter for individual states to decide. But in the case of Obergefell against Hodges, 2015, by a majority of 5-4, the U.S. Supreme Court ruled that marriage is a fundamental right guaranteed to same-sex couples by both the Due Process Clause and the Equal Protection Clause of the 14th Amendment to the Constitution. The ruling requires all states to issue marriage licenses to same-sex couples and to recognize same-sex marriages solemnized in other jurisdictions. In his dissenting opinion, Justice Scalia scathingly characterized the majority opinion as, quote, lacking even a thin veneer of law, unquote, and as descending, quote, to the mystical aphorisms of the fortune cookie, unquote. See Chapter 23 for more on this case. Are states allowed to secede from the Union? The Supreme Court says no. The last time secession was tried, it took a civil war to end it. Since that time, a number of groups have advocated the secession of a state, a city, or a tribe, but no serious attempt has been made. One such group, the Alaskan Independence Party, hit the news during the 2008 election campaign because of alleged links with Sarah Palin, the Republican vice presidential candidate. These points are just the tip of the iceberg when it comes to constitutional controversies, and I devote a good deal of time in this audiobook to sifting through them and offering my own humble opinions of the Supreme Court's interpretations. If the Constitution were not a source of so much debate within the halls of government, perhaps it wouldn't be nearly as interesting to hear about them. Luckily for you, that isn't the case. Chapter 2. Probing Underlying Concepts, Big Thinkers, Big Thoughts. The United States started out as 13 British colonies that overthrew the British yoke, which was no joke at all. Sorry about that. The American Revolution and the War of Independence led to the birth of a new nation and a new form of government enshrined in a written constitution, which, with a number of changes, has survived for more than 200 years. Although the United States was born out of a bitter struggle with Britain, the leading citizens of the new nation, including the framers of the Constitution, were of British stock. They were educated men steeped in English law and familiar with British political institutions and philosophy. No wonder, then, that the U.S. Constitution drew on these British sources. But no wonder either that it departed from British traditions in some major ways too, sometimes deliberately and sometimes accidentally. In this chapter, I discuss some of the British constitutional documents, political writings, and doctrines that were most venerated by the founders of the United States, including Magna Carta, Habeas Corpus, the rule of law, natural law, the consent of the governed, and republicanism. Let's start by looking at Magna Carta. Magna Carta, which is Latin for Great Charter, is a document dating back to the year 1215, containing a number of concessions made by King John of England to his rebellious barons. What relevance could this kind of document possibly have to the United States nearly 8 centuries later? The Founding Fathers used Magna Carta as a justification for the Declaration of Independence and later as a precedent for some features of the U.S. Constitution. Such is the veneration accorded this document in the United States that in 1957 the American Bar Association erected a memorial to Magna Carta in England, and a 1297 reissue of Magna Carta sold at auction in 2007 for $21.3 million, and that sits in a glass case in the National Archives Rotunda in Washington, D.C., right beside the original texts of the Declaration of Independence and the U.S. Constitution. If you take the trouble to read Magna Carta, you'll probably find it just about as riveting as a phone book, even if you speak Latin at home, because that is the language in which Magna Carta is written. The good bits of Magna Carta are few and far between. Here is the most quoted provision. No free man shall be arrested or imprisoned or deprived of his rights or property or outlawed or exiled, except by the lawful judgment of his equals or by the law of the land. Here are a few examples of ways Magna Carta may have influenced the Founding Fathers, as evidenced in the Declaration of Independence and the U.S. Constitution. First of all, taxation without representation. Did Magna Carta actually prohibit taxation without representation? Clause 12 of the original Magna Carta promised, quote, no scutage or aid shall be imposed on our kingdom, except by the common council of our kingdom, unquote. Scutage and aid were 2 feudal taxes on knights and barons alone. But did this mean that a tax could be imposed only with the consent of those subject to it? Possibly. The American patriots certainly thought so. When in 1765 the British Parliament passed the Stamp Act, taxing everything from newspapers to playing cards and dice, the Massachusetts Assembly declared the act, quote, against the Magna Carta and the natural rights of Englishmen, and therefore null and void, unquote. I discuss the concept of the consent of the governed in connection with the Declaration of Independence later in this chapter. Trial by jury. Did Magna Carta, in particular the clause just quoted earlier, did Magna Carta guarantee trial by jury? The clause supposedly guaranteed everyone the right to be tried by their equals, or peers, sometimes translated, or fellow citizens. In fact, this right took a lot longer to be established in England, and it has now largely been lost there, except in cases of serious crime. But the right to a trial by jury sure is alive and well in the United States, and is enshrined in the 6th and 7th Amendments to the Constitution, which I deal with in Chapter 18. Habeas corpus. Did Magna Carta guarantee habeas corpus? The right to take legal action to end unlawful detention. Not exactly. But Magna Carta was a trailblazer for this later right. The passage from Magna Carta quoted earlier in this section promises that nobody is to be imprisoned except after a proper trial. But this right did not become available right away. As late as 1628, King Charles I had 5 knights imprisoned, quote, by His Majesty's special commandment, unquote. Habeas corpus became a major issue in the ensuing English Revolution, resulting in Charles I's execution. Habeas corpus was eventually incorporated into statute in 1679. This important privilege, not a right actually, it's a privilege, is now enshrined in Article 1, Section 9 of the U.S. Constitution. Quote, "The privilege of the writ of habeas corpus shall not be suspended unless when, in cases of rebellion or invasion, the public safety may require it," unquote. Habeas corpus became a hot-button issue in the final year of the Bush administration with regard to detention in Guantanamo Bay in the case of Boumediene versus Bush in 2008. Now let's have a look at the rule of law, or is it the rule of lawyers? The rule of law is commonly regarded as a fundamental principle of the Western world and of the United States in particular. The phrase rule of law sounds impressive, but what exactly does it mean? At its simplest, the rule of law just means that nobody is above the law. This principle was used as a stick to beat the old absolute monarchs of Europe, like King Louis XIV of France, who famously boasted, "I am the state," or even the weak Louis XVI, who is reported as asserting, "It's legal because I wish it." The counterblast to such exorbitant claims was put by the English political philosopher James Harrington as the empire of laws and not of men. John Adams adapted this concept slightly and introduced it into the Massachusetts Constitution of 1780 as, quote, "a government of laws and not of men," unquote. In its most euphonious form, it became, quote, "a government not of men but of laws," unquote. This high-sounding ideal was echoed by Chief Justice John Marshall in the leading case of Marbury versus Madison, which is discussed in Chapter 23. But how can law rule? Laws are just words on paper. They are therefore subject to interpretation by courts, judges, and lawyers, who argue their interpretations of laws to the courts and hope that their interpretations will be accepted. An anonymous wag put his finger on this truth and retorted that what the Founding Fathers were really likely to establish was a government not of laws, but of lawyers. This throwaway line has proved prophetic, and even some Supreme Court justices have admitted that the meaning of the U.S. Constitution changes in accordance with the changing views of the court. In the words of Chief Justice Charles Evans Hughes, quote, "We are under a Constitution, but the Constitution is what the judges say it is," unquote. This oft-quoted remark comes from a speech that Hughes gave as governor of New York in 1907, long before becoming a Supreme Court justice. But he was already pompous enough to add, quote, "and the judiciary is the safeguard of our liberty and our property under the Constitution," unquote. Suzette Kelo, who nearly lost her lovely salmon-pink Victorian cottage because of a particularly unjust decision by the U.S. Supreme Court in 2005, would probably not agree with Hughes' comment. listen to my discussion of eminent domain under Chapter 17. The principle of the rule of law does not figure in the U.S. Constitution in so many words. The closest thing to the rule of law that appears in the Constitution is the Supremacy Clause in Article 6, which reads as follows, quote, "This Constitution and the laws of the United States which shall be made in pursuance thereof, and all treaties made or which shall be made under the authority of the United States shall be the supreme law of the land, and the judges in every state shall be bound thereby, anything in the Constitution or laws of any state to the contrary notwithstanding." Unquote. This clause clearly places federal law above state law. But does it give the U.S. Constitution higher status than the rest of federal law? Article 5 sure makes it difficult to amend the Constitution, but that in itself doesn't prove that the Constitution trumps all other laws. Chief Justice John Marshall, in the case of Marbury v. Madison, went to great lengths to show that the Constitution has higher status than any other law, and that, quote, "a law repugnant to the Constitution is void," unquote. This was a new judge-made principle, and enabled the Supreme Court to arrogate to itself the power of judicial review, which was to become its strongest weapon against the other branches of the federal government. We'll talk more about that in Chapter 23. The power of the Supreme Court to strike down laws found to be unconstitutional is now taken for granted. But was that the intention of the Founding Fathers? Thomas Jefferson objected strongly to the way the Supreme Court usurped, that's the phrase he used, usurped the right of exclusively explaining the Constitution, adding that, quote, "the Constitution on this hypothesis is a mere thing of wax in the hands of the judiciary, which they may twist and shape into any form they please," unquote. A more accurate prediction about the Constitution would be hard to find. Now let's have a look at the concepts underlying the Declaration of Independence. The American colonists had an ambivalent attitude towards the British Constitution. Their leaders steeped themselves in the traditions of the British Constitution and generally identified with the revolutionary spirit that had led to the execution of one king, Charles I, in 1649, and the expulsion of another, James II, in 1689. They regarded themselves as entitled to the same rights as natural-born Englishmen, but found themselves treated at best as second-class subjects. At first they appealed to King George III for redress of their grievances, but when their heartfelt pleas fell on deaf ears, they decided to throw off the British yoke altogether and declare independence. But on what basis could they justify this revolutionary step? Although they felt excluded from the British Constitution because they were denied a voice in the British Parliament, they invoked the principles underlying Britain's embryonic democratic system, most notably the principles of no taxation without representation and government by consent of the governed. Thomas Jefferson took just 17 days to construct the case for American independence in the Declaration of Independence, whose rolling prose and unforgettable phrases were based on a blend of traditional British principles with some European ideas. The Declaration of Independence, adopted on July 4, 1776, by the Second Continental Congress, as it's called, marks the birth of the United States as a new nation. Or does it? Upon closer inspection, the Declaration actually announces the birth of not one, but 13 new nations, each of the former colonies being a separate nation. I say more about that in Chapter 7. But whether the Declaration announced one birth or a litter of 13 births It was a document essentially justifying the throwing off of British colonial rule. The Founding Fathers were not natural revolutionaries. They were educated, well-to-do men of property and pillars of society who wouldn't normally have been mixed up in violence or war. So what impelled these solid citizens to become involved in a bloody conflict that lasted 6 years? The slogan that first rallied opposition to Britain was, "No taxation without representation." The American colonies had elected legislatures, but the British Parliament could override these colonial legislatures and pass laws without consulting them. The Stamp Act of 1765 was an example of this. It slapped a tax on everything from newspapers to playing cards and dice, without any consultation with the colonists. The high-handedness of this action rankled the colonists. Did the colonists have a legal right to consent to decisions that affected them? Not under the British Constitution as understood at the time. So the colonists had to look elsewhere. England itself had a revolution, or 2 revolutions to be precise, in the 17th century. The colonists naturally found themselves drawn to the rhetoric of those revolutionaries who had relied a good deal on Magna Carta, to which they gave a very broad interpretation. But Magna Carta was not enough on its own to justify throwing off the British colonial yoke. Magna Carta belonged to a bygone feudal age. Most of the rights contained in Magna Carta were concessions made by King John to the barons, and did not apply to ordinary people. During the English revolutions of the 17th century, the opponents of the Crown glamorized and reinterpreted Magna Carta in ways that were not always very convincing. The American founders adopted the same expansive approach to Magna Carta, but they also used the following concepts that are reflected in the Declaration of Independence: natural law, inalienable rights, or what they call unalienable rights, consent of the governed, and republicanism. Let's first look at the law of nature, or natural law. The Declaration of Independence opens with a claim on behalf of the American people to the separate and equal station to which the laws of nature and of nature's God entitle them. The concept of the law of nature, or natural law, goes back to ancient Greece and Rome, and it was commonly equated with the law of God, or divine law, and also with the law of nations. Natural law theory said that man-made law, or positive law, was valid only if it conformed to the moral standards laid down by natural law, which was rational, universal, unchanging, and everlasting. The only problem with natural law was that there was no agreement about its content, as it was unwritten and existed only in the minds of its adherents. For example, was slavery in accordance with natural law? Some natural law advocates said yes, others no. The Declaration of Independence claimed that the American states were entitled to independence from Britain on the basis of the supposed natural law principle that each nation, or people, has the right to national self-determination. That supposed principle formed no part of the British Constitution, and was not even recognized in international law, with major modifications, until the 20th century. What about unalienable rights, or what we would today call inalienable rights? Natural law was popular among educated Americans in the late 18th century, but the problem with natural law was that those who supported it could disagree violently about its content. So although the founders relied on natural law, it provided a pretty shaky foundation for American independence. The Declaration of Independence is on firmer ground when it declares that it's the people's right, and even their duty, to overthrow a despotic government and to replace it with a government that will protect their unalienable rights. This assertion is proclaimed in ringing tones. We hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness, that to secure these rights, governments are instituted among men, deriving their just powers from the consent of the governed. These are just about the most sacred words of any American founding documents, but we need to delve just a little beneath their surface. Let's take a look at some of these rolling phrases. We hold these truths to be self-evident, for example. That is an admission that these truths cannot be proved. They are self-evident. All men are created equal. Well, how could that statement be reconciled with slavery? Thomas Jefferson himself, the author of the Declaration of Independence, was a slave owner, as were many other founding fathers. Similar wording in the Massachusetts Constitution of 1780 led to a legal challenge to slavery in the state courts, which effectively ended slavery in that state. But slavery was legally abolished throughout the nation only with the ratification of the 13th Amendment in 1865, which I will say something about in Chapter 20. Creator, the word creator, appears. Does the appearance of this word and the appeal to the supreme judge of the world later on in the Declaration of Independence mean that the United States is based on acceptance of religious belief? The last verse of the U.S. national anthem, Star-Spangled Banner, contains the words, "And this be our motto, in God is our trust." The motto, "In God we trust," has appeared on the penny since 1909, and since 1956 it has been the official national motto of the United States. But is this public display of religious belief in accordance with the First Amendment? I discuss this important subject in Chapter 14. Unalienable rights, or in modern English, inalienable rights, refer to something that cannot be taken away or even given away. Inalienable rights are therefore fundamental rights that automatically belong to every human being. They can be seen as God-given rights or as rights conferred by natural law, similar, therefore, to what are commonly labeled natural rights. Not everybody believes that such rights actually exist. The British philosopher Jeremy Bentham famously declared, "The idea of rights is nonsense, and the idea of natural rights is nonsense upon stilts." Life, liberty, and the pursuit of happiness. This phrase is a variant on the phrase lives, liberty, and property that appeared in the Articles of Association of the First Continental Congress in 1774. The pursuit of happiness is broader than property and harder to pin down. In the case of Loving versus Virginia, decided in 1967, the U.S. Supreme Court struck down a Virginia statute outlawing interracial marriage on the ground that, quote, "the freedom to marry has long been recognized as one of the vital personal rights essential to the orderly pursuit of happiness by free men." Even the term liberty is hard to define. In Meyer versus Nebraska, the U.S. Supreme Court decided in 1923 that a Nebraska law banning the use of a foreign language as the medium of instruction to kids in grade school was unconstitutional and a denial of the liberty protected by the Due Process Clause of the 14th Amendment. Justice Anthony Kennedy commented in the year 2000 that had Meyer's case been decided more recently, it probably would have been based not on the 14th Amendment, but rather on the First Amendment's protection of freedom of speech, belief, and religion. What about the phrase, deriving their just powers from the consent of the governed? The Declaration of Independence says, to secure these rights, governments are instituted among men, deriving their just powers from the consent of the governed. In other words, the purpose of government is to safeguard the rights of the people, and the only legitimate type of government is one based on popular consent. But what exactly is meant by consent of the governed? By putting these words into the Declaration of Independence, Thomas Jefferson gave early notice that the government of the new United States was to be based on consent. New state constitutions soon followed suit, with elected governors and legislatures, and the government of the United States itself was designed on the same pattern, although it was at first confined under the Articles of Confederation to a Congress made up of delegates appointed by the state legislatures. But how genuine was the claim that the governments set up by the American patriots did indeed govern by consent of the governed? It doesn't take much scrutiny to see that the American Revolution was not a democratic revolution. Instead, it was the overthrow of a colonial power by a wealthy elite who then naturally stepped into the shoes of their former colonial masters. In fact, the framers never claimed to be Democrats, and the word democracy does not appear anywhere in the U.S. Constitution. In establishment circles in the American colonies, as in England, democracy was a dirty word. John Adams, the future president, attacked the proposals of the radical Thomas Paine as, quote, so democratical, without any restraint or even an attempt at equilibrium or counterpoise, that it must produce confusion and every evil work, unquote. James Madison, often described as father of the Constitution and also a future president, was no fan of democracy either. Indeed, he attacked it in even stronger terms than the more conservative Adams. Here's what Madison said about democracy. Democracy is the most vile form of government. Democracies have ever been spectacles of turbulence and contention, have ever been found incompatible with personal security or the rights of property, and have in general been as short in their lives as they have been violent in their deaths. The founders just didn't trust the ordinary people and deliberately kept them at arm's length, as can be seen from the way they drafted the Articles of Confederation and then the U.S. Constitution. Keep listening to understand what I mean by that. Now, what about the term republic? The Founding Fathers were not Democrats, so what were they? The concept that they embraced was republicanism. John Adams, the same John Adams who attacked democracy, waxed lyrical in his praise of republicanism. Here's how Adams defined it. A government in which all men, rich and poor, magistrates and subjects, officers and people, masters and servants, the first citizen and the last, are equally subject to the laws. As you continue hearing this definition, you get the impression that it's going to be egalitarian, based on the equality of all people, but the last phrase gives the game away. Republicanism, according to this definition, isn't about any power that the people have, but about a power that they are under. In a republic, says Adams, everybody is equally under the law. This definition of republicanism ties in with Adams' better-known statement of the goal aimed at by the newly independent states. As I mentioned earlier, this objective was so fundamental to Adams that he incorporated it into the Massachusetts state constitution, a government of laws and not of men. Adams' ideal was not one of people power at all. Rather, his ideal was one in which the people were subservient to laws made by an elite group, of which he was a prominent member, with the last word on the interpretation of those laws going to judges drawn from the same elite group. Democracy doesn't figure in the U.S. Constitution at all, but republicanism sure does. Article 4, Section 4 says, "The United States shall guarantee to every state in this union a republican form of government." There is no precise definition of republicanism or republican, but Adams' views on the subject are a reflection of the framers' thinking, although Adams himself did not attend the Constitutional Convention, as he was serving as U.S. ambassador to Britain at the time. Getting rid of the king. The absence of a king is an important aspect of republicanism. The main body of the Declaration of Independence is taken up with a long list of grievances against King George III. Most of these grievances start with the word he, referring to the king in person. The truth is that King George did not call all the shots personally. He delegated a lot of his power to his ministers, and he just didn't have a great deal of power. Later in life, after the American Revolutionary War, the poor guy was replaced by his son as regent because King George suffered from serious mental illness. As a result of the whole system, not just his madness, the king was in reality no longer head of government, but only head of state, an increasingly purely ceremonial position in which the king represented the nation but was under pressure to become politically neutral. This British model of government, in which the head of state is separate from the head of government, has spread around the world, not only among monarchies, but also widely among republics, including Germany, Italy, Poland, India, and Israel. But the American revolutionaries didn't understand these subtleties about British rule. As far as they were concerned, their main enemy was King George. For this reason, among others, the form of government of the United States was not about to be a monarchy. It would be a republic with a president who combined the positions of head of government and head of state. In other words, an executive presidency. The framers never even realized that the separation between head of state and head of government was possible, let alone desirable. So the U.S. Constitution was not intended to set up a democracy. Here is why. First, the Senate was not originally directly elected, but made up of members appointed by the state legislatures. The president was not elected by the people, but by an electoral college. The electoral college system still exists, but thanks to the rise of political parties, it has been short-circuited and is therefore more democratic than the framers ever intended. I discussed presidential elections in Chapter 10. And even elections to the House of Representatives, the only body directly elected under the original version of the U.S. Constitution, were not truly democratic because the right to vote was narrowly restricted in the early days of the Republic. It took more than half a century before the United States could be described as a democracy. The movement towards democracy was largely the achievement of a political party that started out by calling itself the Republican Party, then the Democratic Republican Party, and later, under Andrew Jackson, simply the Democratic Party. Andrew Jackson was president from 1829 to 1837. Let's just say a word about these different terms: confederation, federation, and union. The word confederation is not the same as federation. Confederation is the weakest type of association between a number of independent regions cantons, or states. The central government barely exists and is in control only of foreign affairs and defence. The best example of a confederacy or confederation is Switzerland, although since 1848 it has really been a federation rather than a confederation. America has had two totally unconnected confederacies at two different times. First, the confederacy that lasted from 1777 until 1788, governed by the Articles of Confederation. However, the articles stated at the beginning that, quote, "the style of this confederacy shall be the United States of America," unquote. Slightly confusing. And secondly, the Confederate States of America, the 11 breakaway southern states that seceded from the United States, resulting in the Civil War in 1861. Now, the word federation. The U.S. Constitution established a federal system of government, in which quite extensive powers were delegated to the national or federal government. But any powers not delegated to the federal government were, and still are, retained by the states or by the people. I'll say more on this topic in Chapter 19, which deals with the 10th Amendment. Now, the word union actually appears quite a few times in the U.S. Constitution in reference to the federal government, and it's still often used in that sense. For example, the President's annual State of the Union address. In fact, union is a misnomer as a description of a federal system. Strictly speaking, the word union refers to a much more centralized form of government where all power is concentrated in the national government, as in present-day France, for example. Chapter 3. Untangling some confusion and ambiguities. The U.S. Constitution is only a few pages long. It makes a pretty neat pocket-sized pamphlet. So why do you need to listen to this long audiobook when you can just read the Constitution itself? Well, one reason is that my publishers need to make a few bucks. It's not for my benefit. We authors only get peanuts. No, just kidding. Seriously, though, there are many reasons why everybody, and I do mean everybody, needs help to understand the Constitution. I explore these reasons in this chapter so you can begin to understand why this short document is such a source of confusion and debate. Here are some of the key reasons the Constitution is such a difficult document to digest. First of all, technical language. The Constitution is a statement of law, so it's not surprising that it contains some legal jargon. For example, ratifying an amendment is not the same thing as ratting on that amendment. To ratify an amendment means to confirm it. To change the Constitution, for example, it's necessary for an amendment to be proposed and then ratified. The Fifth Amendment deals with that process. I'll talk about that in Chapter 5. Old-fashioned language, I've already said something about that before. Most of the Constitution was written more than 200 years ago. The meanings of some words have changed a bit since then. For example, what is the meaning of the word compact? As in, quote, "No state shall, without the consent of the Congress, enter into any agreement or compact with another state or with a foreign power," unquote. In modern English, compact often refers to something that occupies very little space. As a noun, compact can mean a small cosmetic case containing face powder, for example. But in the clause that I just quoted from Article 1, Section 10 of the Constitution, compact means an agreement or an alliance related to the word pact. So the quoted words mean that individual states are not allowed to pursue their own foreign policy. This provision gives the federal government a lock on foreign policy. Another reason is old-fashioned ideas. Just as a lot of the language of the Constitution is old-fashioned, So are some of the ideas and values that it expresses. For example, the Seventh Amendment guarantees a right to trial by jury in any civil suit where the value in controversy shall exceed $20. In 1791, when the Bill of Rights, including the Seventh Amendment, was ratified, the average wage earner made only about $16 a week. Times have certainly changed, but in this case the discrepancy is not important. If anything, it's good that the threshold for jury trial is so low, because that means the trial by jury is available for almost all civil suits. Obsolete concepts. The Constitution is based on old concepts and ideas. But does that mean the Constitution is no longer relevant to the present day? Some people have levelled this accusation against the Constitution. I examine this serious charge in this chapter later on. Ambiguity. The framers of the Constitution were educated, articulate men, but even these intellectual giants made a few boo-boos. I'll say more about that a bit later. Omissions. Some of the most important constitutional concepts and institutions don't actually figure in the Constitution itself at all. I've mentioned this before. These missing features include democracy, political parties, the death penalty, privacy, and abortion. The death penalty does at least rate a couple of indirect mentions in the text of the Constitution, but the rest of these missing concepts don't get any mentions at all. I'll come back to that when I talk about giving some important principles the silent treatment. And then, of course, interpretation. The U.S. Supreme Court has made a lot of major changes to the Constitution without altering a single word of the text. This is the most important reason why just picking up and reading the Constitution doesn't really tell you what it means. I'll come back to that when I deal with interpreting the Constitution. Discarding out-of-date ideas. It's easy to criticize the Constitution as being past its sell-by date. The framers recognized the danger that later generations might want to keep changing the Constitution in accordance with shifting political fashions. That's why the framers deliberately made the Constitution so difficult to amend. I discuss this when we come to Chapter 5 for the official and unofficial ways the Constitution has been changed. Here are just 3 of the many constitutional provisions that have been singled out for attack as obsolete. The right to bear arms, contained in the Second Amendment, has always been controversial. But is it also obsolete? That depends on how it's interpreted. If you interpret the amendment as giving individuals the right to buy and use guns, the amendment appears obsolete to those people who view that right as part of a long-gone Wild West culture. But that same interpretation is seen as sensible and relevant to modern life if viewed from the perspective of human rights, and it's the interpretation now accepted by the Supreme Court. On the other hand, if you interpret the Second Amendment as protecting gun ownership and usage only by people who participate in state militias, the amendment may be seen as obsolete. That's because the National Guard, which is the modern successor to the militia, has since 1933 been a component of the U.S. Army, and its members sure don't have to provide their own weapons. But that narrower interpretation is seen by its supporters as relevant to the need for gun control. I'll come to that when we reach Chapter 15. The right to trial by jury, guaranteed for criminal trials by the Sixth Amendment and for civil trials by the Seventh Amendment, may be seen by some as anachronistic. Jury trial originated in England, but it has disappeared there from practically all civil trials and even in criminal trials it's available in far fewer cases than it used to be. However, as a practicing trial lawyer, I would prefer to try a case in front of a bunch of ordinary folk than in front of any judge you can name. The Electoral College system for picking the president, as laid down by Article 2, Section 1 of the Constitution and modified by the 12th Amendment, is often criticized as obsolete because it doesn't appear to be democratic. There's actually confusion here between two different things: the Electoral College system on the one hand, and on the other, the winner-take-all system. In most states, these two systems are combined. That means that the winner of the presidential race in a particular state usually takes all the electoral votes of that state. So if the Democratic Party candidate gets 60% of the votes in California and the Republican candidate gets 40%, all 55 of California's electoral votes go into the Democratic column. But the Constitution doesn't actually demand this approach. The Constitution only says that the electoral vote for a state is calculated by adding the number of representatives for that state in the House of Representatives to the number of senators, which is always 2, of course. If California preferred, it could adopt a split vote system. For example, California could decide to split the electoral vote in the same proportion as the popular vote. So, if the Democratic candidate won 60% of the vote, that candidate would get 60% of California's 55 electoral votes, which is 33 votes, and the Republican candidate would get the remaining 22. If every state adopted this form of the Electoral College system, the Electoral College system would produce the same result as a straight popular vote system calculated without reference to state boundaries, which is what most critics of the Electoral College system are angling for. Whether a state goes for the winner-take-all system or for a split-vote system is entirely a matter for that state to decide. At present, Nebraska and Maine are the only two states that operate a form of split vote, and that system did actually produce a split vote in Nebraska in 2008 and Maine in 2016. Now, what about clarifying uncertainties? The Constitution has a reputation for being unclear or even ambiguous at times. If it weren't, the members of the Supreme Court might have a lot more free time on their hands. Consider just 2 examples. Does the Second Amendment give individual citizens the right to keep and bear arms? Or does it restrict the right to members of militias or their modern equivalent? James Madison, who drafted the amendment, must have known what he intended it to mean, but he didn't express it very clearly. As I explain when we come to Chapter 15, proponents of both sides of the gun rights debate find support for their arguments within the murky structure of this one-sentence amendment. To take another example, what happens if the vice president takes the reins when the president dies or resigns? Is the VP actually the president or just the acting president? Article 2 of the Constitution is clear as mud, and the issue became very real when William Henry Harrison died in 1841 after just a month in office, and Vice President John Tyler took over as president. Tyler refused to be just an acting president, and he set a precedent that was followed by every subsequent VP. But it was only in 1967 that the 25th Amendment finally settled the issue in crystal clear language. For more detail on that, we will come back to that in chapters 4 and 22. Giving some important principles the silent treatment. The whole idea of a written constitution is to lay everything on the line. Chief Justice John Marshall famously remarked, "The government of the United States has been emphatically termed a government of laws and not of men." But how can this ambitious ideal ever be achieved if the Constitution omits all mention of some of the most important principles on which the Constitution is based? Here are some important principles and institutions that don't figure in the text of the Constitution at all. Democracy. I did mention this before, but the words democracy and democratic don't figure anywhere in the text of the Constitution. Is the United States a democracy? It sure wasn't in the early days of the Republic. The founders didn't trust the ordinary people. Democracy was a dirty word as far as they were concerned. Voting rights were restricted to property owners, and the House of Representatives was the only directly elected federal institution. Senators were appointed by state legislatures, and the president was elected by an electoral college. The electoral college system is still in place today, but it's now largely nominal. The existence of parties has short-circuited the Electoral College and democratized presidential elections. I've already dealt with this to some extent. The U.S. Constitution doesn't read as a blueprint for a democracy, simply because democracy was not on the agenda as far as the founders were concerned. Political parties is another important concept that's not referred to. The Constitution contains not a single reference to political parties, but political parties are the lifeblood of the Constitution. The competition between the parties has made the United States much more democratic than it would otherwise have been. Parties started crystallizing quite early on, but the framers didn't recognize their importance. As a result, the presidential election of 1800 was a mess, and the 12th Amendment was needed to remedy the situation. I'll come on to that when we deal with Chapter 20. The United States has always had two main parties competing for power. At first, Federalists and Republicans, or Democratic Republicans, then later Whigs and Democrats, and since 1854, Republicans and Democrats. This two-party system gives voters a choice and prevents power from being concentrated in the hands of one group. The death penalty. The Constitution doesn't specifically allow or disallow the death penalty, but both the Fifth and the 14th Amendments refer to it. The Fifth Amendment opens with these words, "No person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury." A capital crime means a crime carrying the death penalty. Which crimes were these? The amendment doesn't say, but it takes it for granted that such crimes exist. Murder is the most common capital crime, but it's usually a state crime rather than a federal crime, and the Fifth Amendment refers purely to federal law. The 14th Amendment does refer to state law, and the Due Process Clause in Section 1 of that amendment recognizes the death penalty. Nor shall any state deprive any person of life, liberty, or property without due process of law. For a state to deprive somebody of life by due process of law can only mean that execution was a recognized sentence in 1868 when the 14th Amendment was ratified. So how come the Constitution doesn't say so in so many words, that capital punishment is okay as long as certain due process is given? Because the Constitution doesn't restate the whole of the criminal law, which had always imposed the death penalty for murder, treason, and other so-called infamous crimes. The presence of these references to capital punishment in the Fifth and 14th Amendments, side by side with the ban on cruel and unusual punishments in the Eighth Amendment, makes it crystal clear that capital punishment in itself was not viewed as being cruel and unusual. However, the mode of execution could well make a difference as far as the Eighth Amendment is concerned. For example, execution by boiling in oil or by tearing the offender limb from limb would undoubtedly qualify as cruel and unusual punishments. Execution by lethal injection is acceptable, according to the 2015 U.S. Supreme Court ruling in the case of Glossip v. Gross. The case arose out of a challenge by two men sentenced to death by lethal injection in Kentucky. Ralph Bays was convicted of murdering a sheriff and deputy sheriff who were trying to serve him with a warrant. Thomas Bowling was convicted of killing a husband and wife after ramming their car. The test used by the U.S. Supreme Court for cruel and unusual punishments is whether the punishment in question carries the risk of inflicting, quote, unnecessary pain, unquote. In the words of Chief Justice John Roberts, writing for the majority on the court, quote, Kentucky has adopted a method of execution believed to be the most humane available, one it shares with 35 other states, unquote. I'll say more about the death penalty when we get to Chapter 18. Privacy. The word privacy also doesn't figure anywhere in the text of the Constitution. However, in the case of Griswold versus Connecticut, decided in 1965, Justice William O. Douglas, writing for the majority, found the right to privacy in the so-called penumbras formed by, quote, emanations of guarantees contained in the First, Third, Fourth, and Fifth Amendments. Concurring judgments cited also the Ninth and 14th Amendments. Judge Potter Stewart disagreed, stating, quote, with all deference, I can find no such general right of privacy in the Bill of Rights, in any other part of the Constitution, or in any case ever before decided by this court, unquote. But the powerful dissent by Stewart, joined by Justice Hugo Black, wasn't enough to block this far-reaching reinterpretation by the majority on the court. Say more about that when we get to Chapter 5. Abortion. The newfound right to privacy served as the springboard to a right of abortion in certain circumstances. This controversial right was established by the court in Roe v. Wade, which I discuss in Chapter 5. Now, interpreting the Constitution. Chief Justice Charles Evans Hughes famously remarked that, quote, we are under a Constitution, but the Constitution is what the judges say it is, and the judiciary is the safeguard of our liberty and our property under the Constitution, unquote. The Chief Justice was right to point out that the meaning of the Constitution keeps changing as a result of judicial interpretation and reinterpretation, without any change in the words on paper. Hughes was not criticizing the courts for this process, but was actually praising them. Not everyone would agree with this view. Here are some of the reasons for opposing judicial changes to the Constitution. Article 5 of the Constitution makes it clear that the only way that the Constitution can be changed is by formal amendment, which requires a two-thirds majority in both houses of Congress and ratification by 3/4 of the state legislatures. Secondly, the framers deliberately made amendment difficult so that any change would command broad general support. Thirdly, the Supreme Court justices are unelected, are appointed for life, and are removable only by impeachment. This means that the justices are independent and not answerable to the electorate or to anybody else. Another point is that Supreme Court justices who interpret the Constitution in ways that depart from the text are effectively rewriting that document by imposing their own views on it. But of course, these criticisms aren't shared by everybody, and the reply to those points is along the following lines. Firstly, the Constitution was mostly written more than 200 years ago. It's impossible to get back to the original intention of the framers, even if we wanted to. Second, to remain relevant and meaningful, the Constitution must be interpreted afresh by each generation as a, quote, living Constitution, unquote. Thirdly, this process of interpretation in the light of changing political, social, and moral values does not amount to unauthorized amendment, but is needed to make sense of the Constitution and to apply it to the modern age. Now, we can classify the different schools of constitutional interpretation, and it is messy to say the least, but here is a bird's-eye view of the main division. Firstly, the living Constitution school. This school of thought sees the Constitution as a living and breathing document that must be interpreted and reinterpreted according to society's changing needs. On the present Supreme Court, Justices Breyer, Ginsburg, Kagan, and Sotomayor generally adhere to this approach. As Justice Breyer puts it, the Constitution's values don't change, but they, quote, must be applied to a world that changes every 5 minutes, unquote. And, quote, George Washington did not know about the Internet, but he did know about free speech, and the values of free speech have to apply to today's world that includes an Internet, unquote. The late Justice Antonin Scalia attacked this approach as undemocratic by wanting, quote, matters to be decided not by the people, but by the justices of the Supreme Court. And he opposed that idea. A different school of thought is the strict constructionist school. This label is used to refer to a literal approach to constitutional interpretation. Thomas Jefferson favored that approach, which takes a narrow view of the powers of the federal government as against the states. Chief Justice William Rehnquist was often described as a strict constructionist, as are Justices Clarence Thomas and the late Justice Scalia. Scalia rejected the label. Strict constructionism, he explained, is a degraded form of textualism that brings the whole philosophy into disrepute. I am not a strict constructionist, and no one ought to be, though better that, I suppose, than a non-textualist. A text should not be construed strictly. It should not be construed leniently. It should be construed reasonably to contain all that it fairly means, unquote. Scalia went on to provide an illuminating example from the criminal case of Smith versus United States, 1993. The question before the Supreme Court was whether Mr. Smith had used a firearm in the course of committing a drug-related crime. Smith had wished to buy some cocaine, for which he had offered an unloaded gun in payment. Did this amount to using a gun in connection with the drug trafficking offense? The majority on the court, made up of 6 justices, were satisfied that it did. Scalia dissented and explained his dissent as follows, quote, the phrase uses a gun, unquote, fairly connoted use of a gun for what guns are normally used for, that is, as a weapon. When you ask someone, do you use a cane, you are not inquiring whether he has hung his grandfather's antique cane as a decoration in the hallway, unquote. Another school of thought, textualism. Judges who are referred to by politicians and the media as strict constructionists nowadays tend to prefer to be regarded as textualists, formalists, or originalists. These labels are not identical, but they overlap to a considerable extent. Originalism is essentially an approach to the Constitution, while textualism is concerned with other legislation. So there is no contradiction between being both a textualist and an originalist. Scalia referred to himself as, first of all, a textualist, and secondly, an originalist. Textualists are also often regarded as conservatives. But there is some confusion here. Conservative judges normally have a certain reverence for stare decisis, in other words, the doctrine of binding precedent, that courts should adhere to previous decisions. But what should a textualist do when his reading of the Constitution disagrees with a previous Supreme Court decision? In those circumstances, some of them, like Justice Thomas, tend to jettison stare decisis. Scalia is on record as remarking, Clarence Thomas does not believe in stare decisis, period. If a constitutional line of authority is wrong, he would say, let's get it right. I wouldn't do that. And now look at originalism. This term is now applied to several different shades of legal opinion, which share the view that the Constitution had a clear and definite meaning at the time it was drafted, and that to interpret the Constitution, a court must get back to that original meaning. Justice Neil Gorsuch, a Trump appointee who took his seat in April 2017, has been described as a textualist in statutory interpretation and an originalist in regard to constitutional interpretation. He is also known to be an advocate of natural law, having written his Oxford doctoral dissertation on assisted suicide and euthanasia. He's actually against both. In Gorsuch's first criminal case as a Supreme Court justice, his vote tipped the scales against 8 death row inmates from Arkansas who were petitioning the court for a stay of execution, the case called McGehee versus Hutchinson, 2017. Gorsuch wasn't swayed by Justice Breyer's impassioned plea in support of a stay of execution on the ground that, quote, apparently the reason the state decided to proceed with these 8 executions is that the use-by date of the state's execution drug is about to expire, unquote. The most influential branch of this school of thought, claiming adherents such as Scalia, stresses original meaning at the expense of original intent, the meaning of the text as it would have been understood by a reasonable person at the time it was drafted, rather than some secret purpose that the framers may have had. Critics of this approach have pooh-poohed as unrealistic the attempt to recapture the meaning of a text as it was understood more than 200 years ago. The sight of judges beating one another over the head with old dictionaries can be entertaining. In 1994, Scalia, relying on a raft of dictionaries, ruled that the word modify meant no more than to make minor changes. He rejected the argument based on Webster's Third New International Dictionary, published in 1976, that modify could also refer to the making of major or fundamental changes. If this is the sort of mess a court can get into on the basis of word meanings of the late 20th century, how easy can it be to reach the original meaning of texts drafted in the late 18th century? Interpreting the Constitution on the basis of its meaning at the time when it was written sure makes sense. The problem may be that none of the High Court justices were trained as a historian, a linguist, or a philologist. Chapter 4, actually titled Catching a Bird's Eye View of the Constitution, but obviously it'll be an earful of the Constitution in your case. Is the Constitution complicated, hard to understand, and boring? You betcha. Okay, so don't read it yet. Listen to this chapter first. In this chapter, I introduce you to the preamble, which is the introduction to the Constitution, as well as to the 7 articles of the Constitution itself. I deal with the subject matter of these 7 articles in detail in later chapters. My goal in this chapter is to look beneath the surface of the Constitution and identify what I consider to be the most important and sometimes disputed issues it addresses. I also reveal some of the most important principles that formed the basis of the Constitution don't actually figure in the text at all. This chapter doesn't deal with any of the 27 amendments to the Constitution. Those are covered later on. So, let's turn to the preamble. We, the people, are the best-known words of the Constitution. They're the opening words of the preamble, the almost lyrical introduction to the Constitution. We, the people of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our posterity, do ordain and establish this Constitution for the United States of America. The language of the preamble is very different from that of the rest of the Constitution. The Constitution is essentially a legal document, but the preamble reads more like a political statement. Let's take a closer look at the wording. We, the people of the United States, do ordain and establish this Constitution for the United States of America. Did the people of the United States really ordain and establish the Constitution? Yes and no. The delegates to the Philadelphia Convention who drafted the Constitution in 1787 were not directly elected. They were selected by their state legislatures. But the Constitution was then submitted for ratification to a directly elected convention in each state. What about the words, in order to form a more perfect union? This clause refers to the perceived failure of the Articles of Confederation, the first American Constitution, which had been in effect since 1777. The Philadelphia Convention drafted a constitution that aimed, quote, to form a more perfect union, unquote, a closer union than the loose association of sovereign states that existed under the Articles of Confederation. What about the phrase, in order to establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our posterity? This is an impressive list of objectives. The Articles of Confederation were not able to deliver these goals. They didn't even set up any national law courts. The states were at one another's throats, and Congress wasn't able to offer protection against foreign enemies or the Native American tribes. But the framers were confident that their new Constitution could secure these benefits for their own age and for the future. They turned out to be right. Now let's turn to the articles themselves. Article 1. Setting up the Congress. Article 1 is by far the longest article of the Constitution, and Section 1 of that article reads as follows: all legislative powers herein granted shall be vested in a Congress of the United States, which shall consist of a Senate and House of Representatives. At first sight, this section looks as though it gives Congress total legislative power, the power to make any laws it likes. The very first word, all, certainly contributes to this impression, but that impression is false. The most important word in this section is not all, but the easily missed granted. This important section can be rewritten like this: the Constitution grants the federal government certain limited legislative powers, the power to pass laws on certain matters, but not on just anything. Secondly, the Constitution grants all these limited legislative powers to a Congress. And thirdly, the Congress shall consist of two houses, a Senate and a House of Representatives. Sections 2 through 7 of Article 1 spell out who can run for election to each branch of Congress, how often those elections take place, how many members each branch has, and, in broad terms, how the business of Congress is to be run. I'll come back to those topics when we deal with Chapter 11. But by far the meatiest sections of Article 1 are Section 8, which lists the powers of Congress, and Section 9, which details specific limits on congressional power. And I'll explain 2 reasons that Section 8 in particular deserves special attention. Over the years, the Constitution has been interpreted in such a way that the most important part of Article 1, Section 8 is the Commerce Clause, which confers on Congress the power, quote, to regulate commerce with foreign nations and among the several states and with the Indian tribes. The U.S. Supreme Court has at times interpreted this clause, and particularly Congress's power over interstate commerce, so widely as to embrace virtually all economic activities. This interpretation is a far cry from what the framers appear to have intended, because the wording of the clause places interstate commerce slap bang between international trade and trade with the Native American tribes. This positioning can only mean that interstate commerce must be understood in the same limited way as the other 2 categories. I'll come back to the Commerce Clause when I deal with Chapter 9. Misinterpreting the Necessary and Proper Clause. The Necessary and Proper Clause of Article 1, Section 8 is also important, but it too has suffered at the hands of greedy feds. This clause gives Congress the power, quote, to make all laws which shall be necessary and proper for carrying into execution the foregoing powers and all other powers vested by this Constitution in the government of the United States or in any department or officer thereof, unquote. Once again, it's easy to be influenced by the opening words, quote, to make all laws. But a close reading of the rest of the clause appears to indicate a serious limitation. The key words are necessary and proper. Does this phrase apply to all congressional legislation? If it does, then it clearly acts as a limitation on the power of Congress. In the leading case of McCulloch v. Maryland, decided in 1819, Chief Justice John Marshall disagreed with this interpretation and held that, far from restricting the power of Congress, the Necessary and Proper Clause actually extended that power. My own view is that Marshall was wrong about this, and that his interpretation of this clause is one of his many twistifications. Twistifications, a phrase that Thomas Jefferson coined. Article 2, Hailing the Chief. Section 1 of Article 2 begins with these words: "The executive power shall be vested in a President of the United States of America." So we are hailing the chief here. Section 2 adds, "The President shall be Commander-in-Chief of the Army and Navy of the United States and of the militia of the several states when called into the actual service of the United States." In addition to his executive and military powers, President's approval is needed for a bill to become an act of Congress. If the President doesn't approve a bill, he is commonly said to veto it. The presidential veto kills the bill concerned, but the veto can be overridden by a two-thirds majority in both houses of Congress. These legislative powers of the President are found in Article 1, Section 7 of the Constitution. The President is also head of state of the United States, a position that isn't mentioned in the Constitution at all, because the framers didn't recognize it as a separate position. I discuss this and the other powers of the President in Chapter 10. Now let's take a look at presidential powers and duties. Article 2 is surprisingly brief. The only presidential powers and duties that are specifically enumerated are the following. Firstly, the power to make treaties, subject to confirmation by the Senate. Secondly, the power, again subject to confirmation by the Senate, to appoint ambassadors, other public ministers and consuls, judges of the Supreme Court, and all other officers of the United States whose appointments are not herein otherwise provided for. Thirdly, the power to fill casual vacancies in the Senate that occur during congressional recesses. Fourth, the duty to report to Congress on the State of the Union, which is the origin of the annual State of the Union address. Then the power to recommend legislation to Congress. Also, the power to call a meeting of one or both houses of Congress on extraordinary occasions, a power that has been exercised by 16 presidents. Also the power to adjourn Congress in case of disagreement between the two houses with respect to time of adjournment. Also the right to receive ambassadors and other public ministers representing foreign nations. And an obligation to, quote, take care that the laws be faithfully executed, which is a really important duty. And the power to appoint all officers of the United States Armed Forces. Finally, Article 2, Section 4 contains one of the best-known features of the Constitution, the provision for the impeachment of President, Vice President, and all civil officers of the United States. I discuss impeachment in Chapter 13. Now, let's try to identify the real issues. This list of presidential powers and duties looks boringly straightforward. So how come different presidents have exercised such different degrees of power? You need only compare a weak president like James Buchanan with his immediate successor, Abraham Lincoln, to notice the difference. Or, say, a strong president like Theodore Roosevelt with his weak hand-picked successor, William Howard Taft. The reason for these contrasts is the divergent interpretations of the Constitution that these different presidents embraced. These days, the main areas of dispute include, first of all, presidential power in regard to war, secondly, presidential power in regard to homeland security, and thirdly, the president's role in regard to health care. I come back to these topics in Chapter 10. Now, Article 3, understating judicial power. Article 3, which sets forth the power of the judiciary, looks pretty straightforward and mind-numbingly dull. Here's Section 1. The judicial power of the United States shall be vested in one Supreme Court, and in such inferior courts as the Congress may from time to time ordain and establish. The judges, both of the Supreme and inferior courts, shall hold their offices during good behavior. The provision allowing federal judges to hold office, quote, during good behavior, unquote, is effectively the same as saying, for life. That's why the battle over who will receive a coveted appointment to a federal judgeship is often protracted and heated. Quite a number of Supreme Court justices, including Chief Justice William Rehnquist and Justice Antonin Scalia, died in harness. Article 3, Section 2, lists the types of cases that the federal courts are empowered to hear. The U.S. Supreme Court is the most important court in the nation. The inferior federal courts include the U.S. Courts of Appeals, U.S. District Courts, and also specialist courts such as the U.S. Bankruptcy Courts and the U.S. Tax Court. There's only one surprise in the list of judicial functions in Article 3. It includes cases, quote, between a state and citizens of another state, which were later excluded by the 11th Amendment. The most important power of the U.S. Supreme Court doesn't figure in the text of the Constitution at all. This is the power of judicial review, which I discuss at length in Chapter 12. In brief, here is what judicial review means. It allows the Supreme Court to decide whether a federal or state law is in violation of the U.S. Constitution. If the court finds that a law conflicts with the Constitution, it declares the law unconstitutional. This means that the law, or the relevant part of the law, is void or of no effect. Because of judicial review, the Supreme Court is extremely powerful, arguably more powerful than either of the other two branches of government. The court can strike down a law that has been passed by both houses of Congress and signed by the President. To quote the words of Chief Justice Charles Evans Hughes again, quote, "The Constitution is what the judges say it is," unquote. Two key questions come to mind, both of which I discuss in Chapter 12. One, how come this great power of the Supreme Court isn't spelled out anywhere in the text of the Constitution? The framers of the Constitution may not have intended for the court to wield such power. The court arrogated the power of judicial review to itself. Chief Justice John Marshall started the ball rolling with his famous 1803 opinion in Marbury versus Madison, a case I discuss in Chapter 23. Was the court's decision to give itself the power of judicial review wrong? Probably, but nonetheless the power remains intact today. Article 4, getting along with the neighbors and Uncle Sam. The first sentence of Section 1 of Article 4 is known as the Full Faith and Credit Clause. It reads as follows: "Full faith and credit shall be given in each state to the public acts, records, and judicial proceedings of every other state." This clause appears to mean that every state has to recognize the laws and court decisions of every other state. But the Supreme Court established a, quote, "public policy," unquote, exception to the operation of this clause. In 1939, the court ruled that, quote, "there are some limitations to the extent to which a state may be required by the full faith and credit clause to enforce even the judgment of another state in contravention of its own statutes or policy," unquote. It is possible for a state to get around the full faith and credit rule. Between 1996 and 2004, 39 states passed laws defining marriage as the union of a man and a woman. Most of these laws also explicitly prohibited the state from honoring same-sex marriages solemnized in other states and in foreign countries. But the U.S. Supreme Court decision in Obergefell v. Hodges, 2015, made same-sex marriage legal throughout the U.S. and obliged all states to recognize same-sex marriages performed in all other states. The opening sentence of Section 2 of Article 4, the Privileges and Immunities Clause, is less controversial. It reads as follows: "The citizens of each state shall be entitled to all privileges and immunities of citizens in the several states." But even this clause has had its problems, especially when it has come up against the clause modelled on it in the 14th Amendment, which I discuss in Chapter 21. Article 5, changing versus amending the Constitution. Article 5 lays down the rather complicated procedure required for amending the Constitution, or, to be precise, 4 alternative routes that can be adopted for this purpose. With one exception, the 21st Amendment repealing prohibition, the procedure adopted for every amendment has been the same, namely, first of all, proposal by a two-thirds majority in both houses of Congress, followed by ratification by three-fourths of the state legislatures. The framers deliberately and cleverly made the procedure for amending the Constitution as complicated and elaborate as possible, because they didn't want their handiwork undone by the shifting breezes of political fashion. On the face of it, the framers appear to have achieved their objective. Since the ratification of the Bill of Rights, the first 10 amendments, all at once in 1791, only 17 amendments have been made to the Constitution in the space of more than 2 centuries. Does this remarkable fact mean that, with the exception of these 17 amendments, the Constitution today is the same as it was in 1791? No, not at all. It means only that the wording of the Constitution hasn't been changed by formal amendment. There have been plenty of changes, accomplished by judicial interpretation. The power of the Supreme Court is such that it is able to amend the Constitution, sometimes quite radically, by interpreting a word or phrase. I discuss this topic in Chapter 5. Article 6. Fudging Federalism. The most important part of Article 6 is the Supremacy Clause, which reads as follows: This Constitution, and all the laws of the United States which shall be made in pursuance thereof, and all treaties made or which shall be made under the authority of the United States, shall be the supreme law of the land, and the judges in every state shall be bound thereby. Anything in the Constitution or laws of any state to the contrary notwithstanding. This clause purportedly has the following effects. First, it sets federal law above state law. Secondly, it makes the U.S. Constitution the highest law in the land. And thirdly, it also places international treaties above state law. I explore these effects and the questions they raise in Chapter 7. Article 7. Ratifying the Constitution. A nice, easy one at last. Article 7 of the Constitution, the last part of the original unamended Constitution, sets out the requirement for ratifying the Constitution. It's now purely of historical interest and doesn't apply to the ratification of amendments, which is governed by Article 5. Chapter 5. Changing the Constitution by Amendment and Interpretation. How does the Constitution change? Well, only with difficulty. The framers of the Constitution believed they'd hit the jackpot. They had thought and debated long and hard about the best form of government, and they wanted to make sure that future generations wouldn't mess up their perfect construction by adding or subtracting bits arbitrarily. Benjamin Franklin, one of the framers, described the Constitution as creating a system of government that was, quote, near to perfection, unquote. So the framers deliberately made the Constitution very hard to change. Not impossible, just very complicated. I'm talking here about amendments, official, formal changes to the Constitution, but there is another, less formal kind of change through decisions of the U.S. Supreme Court interpreting the Constitution. You won't find that type of change even mentioned in the Constitution, because the framers never imagined change could come about in that way. It simply wasn't supposed to happen. Some of the most important changes to the Constitution have been made as a result of Supreme Court decisions. These include banning racial segregation, expanding the rights of people charged with crimes, declaring a right to privacy, establishing a limited right to abortion, and legalizing same-sex marriage. I'll come back to judge-made changes later on, but first let me discuss the type of change allowed by the Constitution, amendment. There are 4 paths to an amendment. Article 5 provides for no fewer than 4 different ways of amending the Constitution. Ready for some fancy footwork? Well, first of all, Congress proposes an amendment, passed by a 2/3 majority of both houses. This amendment is then ratified, which is to say confirmed, by the legislatures of 3/4 of all the states. Congress proposes an amendment passed by a 2/3 majority of both houses. This amendment is then ratified by special conventions in 3/4 of the states. That's an alternative route. A third way is 2/3 of the state legislatures ask Congress to call a national convention. This convention proposes an amendment which is then ratified by the legislatures of 3/4 of the states. And the fourth approach is 2/3 of the state legislatures ask Congress to call a national convention, and this convention proposes an amendment which is then ratified by special conventions in 3/4 of the state. Phew! But a lot of this technical detail is of academic interest only. The first of the 4 ways of amending the Constitution has by far the greatest practical significance. This method has been used for 26 of the 27 amendments ratified so far. The second method was used only once for the 21st Amendment, which repealed the 18th Amendment on prohibition. And the third and fourth routes for amendment provided by the Constitution have never been used. The President is not involved in the amendment process at all. He can neither propose an amendment nor veto it. This is surprising, to say the least, because Article 1, Section 7 of the Constitution gives the President the right to approve or disapprove, quote, every order, resolution, or vote, unquote, needing the agreement of the House and the Senate. Doesn't this cover amendments as well? On the basis of Article 1, Section 7, it sure looks like it. But Article 5, the article that deals with amending the Constitution, doesn't mention the President at all. In Hollingsworth versus Virginia, decided in 1798, the Supreme Court ruled that the President had no say in regard to amendments. And this is still the position today. Presidents have occasionally, though, signed proposed amendments nevertheless, to give them extra support. In 1861, President James Buchanan signed a pro-slavery proposed amendment for this reason. And in 1865, Abraham Lincoln followed his example by signing the 13th Amendment abolishing slavery. Now let's look at what happens in practice. As is so often the case, the words of the Constitution raise more questions than they answer. Let me tackle a few of these questions. First, 2/3 of both houses of Congress can propose an amendment. Does this mean 2/3 of all members? No, not necessarily. Only 2/3 of those present and voting at the time, provided there's a quorum, which is more than half of the members, present in each house. And what exactly is meant by a convention? A convention is a meeting of delegates, and Article 5 provides for 2 different kinds of conventions: a national convention for proposing amendments and state conventions for ratifying amendments. Who gets to be chosen as a member of a national convention? The only national constitutional convention in U.S. history was the initial Philadelphia Convention that drafted the U.S. Constitution in 1787. The 55 delegates were not elected, but selected by the state legislatures. States have recently made more than 500 requests for a national convention, but Congress has remained resistant to all such requests. The method of choosing delegates to any future convention is undecided. What powers would a national convention have? A national convention would be permitted to propose amendments, but not to ratify them. Why? Because Article 5 of the Constitution leaves the mode of ratification up to Congress. But a national convention would, in practice, have unlimited power to propose amendments or even a radical rewriting of the Constitution, which is probably why Congress is reluctant to agree to another national convention. Who gets to be chosen as a member of a state convention? The only time state conventions were ever called was in 1933 to ratify the 21st Amendment. Different states had different arrangements, but a common method was for the voters in the state concerned to elect delegates from a list chosen by the state governor in consultation with other state officials. What powers does a state convention have? State conventions can ratify proposed amendments, but can't themselves propose any amendments. The 21st Amendment is the only one that has been ratified by this method. What about proposed amendments which didn't quite make it? 6 amendments to the Constitution cleared the first hurdle of congressional approval, but were never ratified. Here they are. First of all, Article 1 of the original Bill of Rights, 1789. This proposed amendment was intended to ensure that the size of the House of Representatives would continue to grow with the population. It stipulated that, as the population grew, quote, there shall not be less than 200 representatives, nor more than 1 representative for every 50,000 persons, unquote. It was ratified by 11 states and is still technically open, needing ratification by 27 more states to become part of the Constitution. But this is most unlikely ever to happen, as the Reapportionment Act of 1929 capped the size of the House of Representatives at 435 members. Foreign titles of nobility and gifts, 1810. This proposed amendment stripped of their citizenship any U.S. citizen who accepted any foreign title of nobility or, quote, any present, pension, office, or emolument of any kind whatever, unquote, from a foreign power. It was ratified by 12 states and is still technically open, needing ratification by 26 more states to be adopted as part of the Constitution. This proposed amendment was an extension of Article 1, Section 9, Clause 8 of the Constitution, known as the Emoluments Clause, which became topical under the Trump administration. The main difference between the Emoluments Clause and the proposed amendment is that the amendment contained a definite and extremely harsh penalty for breach. The Corwin Amendment, 1861. This is probably the most intriguing of the 6 failed amendments. This proposed amendment was the brainchild of lame duck President James Buchanan in a last-ditch attempt to avert civil war. Without using the word slavery, the amendment guaranteed the preservation of slavery in all states where it already existed, without, however, dealing with the vexed question of slavery in the territories or new states. Congress passed this proposed amendment with the requisite 2/3 majority in both houses just 2 days before the end of Buchanan's term, and the President, in an unprecedented move, signed it himself. The widespread support for this amendment in Congress, even after the representatives of 7 southern states had withdrawn, shows that the North had more tolerance of southern slavery than might have been expected. And 2 days later, the new president, Abraham Lincoln, alluding in his inaugural address to the proposed amendment and to the preservation of southern slavery in particular, declared, quote, I have no objection to its being made express and irrevocable," unquote. Ohio and Maryland then ratified the amendment, and Lincoln's own state, Illinois, did so as well, though its ratification was technically invalidated. But it was too late to avert civil war. Had Congress approved the amendment in time for it to be ratified before Buchanan's term expired, there's just a chance that the lives of 620,000 men may have been spared. Child Labor Amendment 1926. This proposed amendment gave Congress, quote, "power to limit, regulate, and prohibit the labor of persons 18 years of age," unquote. It was ratified by 28 states and needs to be ratified by an additional 10 states to become part of the Constitution. But this is unlikely to occur, as the Fair Labor Standards Act of 1938, which the Supreme Court approved in 1941, achieves essentially what the amendment was intended to do. Equal Rights Amendment 1972, also known as the ERA. This proposed amendment was intended to guarantee equal rights for women. The main section of the amendment is very brief. Quote, "Equality of rights under the law shall not be denied or abridged by the United States or by any state on account of sex," unquote. After its passage by Congress in 1972, the ERA was sent to the states with a 7-year deadline for ratification by the requisite 38 states. However, only 35 states had ratified it by the time of the deadline, and in the meantime 4 states rescinded their ratification, though the acting governor of Kentucky vetoed the rescinding resolution of that state's legislature. In 1982, the U.S. Supreme Court ruled that an attempted extension of the deadline was unconstitutional. The reason for the controversy surrounding the ERA was that despite massive support, it also aroused a good deal of opposition among women. Phyllis Schlafly, a leading activist against the ERA, argued that the amendment, quote, "would lead to women being drafted by the military and to public unisex bathrooms," unquote. Opponents of the ERA also claimed that the Equal Pay Act of 1963 and the Civil Rights Act of 1964 made the ERA unnecessary. Washington, D.C. Voting Rights Amendment 1978. This proposed amendment would have accorded Washington, D.C. the same representation as a state. The deadline for ratification was 7 years, during which time only 16 states ratified it. One reason for the failure of this amendment was that it would have repealed the 23rd Amendment ratified in 1961, which gave the nation's capital 3 electoral college votes in presidential elections, but no voting representation in Congress. I come back to this in Chapter 22. In the 200-plus years that the Constitution has been in force, no fewer than 5,000, that's right, 5,000 amendments have been introduced in Congress. Of these, only 33 have gotten over the two-thirds hurdle to be formally proposed, and of these, just 27 have made it through the ratification process to become part of the Constitution. This figure of 27 includes the first 10 amendments, which were all ratified together on December 15, 1791, and are collectively known as the Bill of Rights. This leaves the amazingly small total of 17 amendments in the whole period from 1791 to the present day. List of all the amendments. Here's a rundown of all 27 amendments that have made it into the U.S. Constitution. First Amendment, freedom of speech, religion, and assembly. Second Amendment, right to bear arms. Third Amendment, ban on quartering soldiers. Fourth Amendment, unreasonable search and seizure. Fifth Amendment, grand juries, double jeopardy, self-incrimination, due process, and the taking of private property for public use. Sixth Amendment, jury trial and other rights of defendants in criminal trials. Seventh Amendment, trial by jury in civil suits. Eighth Amendment, cruel and unusual punishments. Ninth Amendment, rights retained by the people. 10th Amendment, powers reserved to the states or to the people. 11th Amendment, ban on lawsuits brought by citizens of one state against another state. 12th Amendment, electing the president and vice president. 13th Amendment, abolishing slavery. 14th Amendment, rights of its citizenship, obligations of the states, and due process. 15th Amendment, ban on racial discrimination in voting. 16th Amendment, income tax. 17th Amendment, direct election of senators. 18th Amendment, prohibition. 19th Amendment, women's right to vote. 20th Amendment, fixing new term dates for the President and Congress. 21st Amendment, repealing prohibition. 22nd Amendment, presidential term limits. 23rd Amendment, voting rights for Washington, D.C. 24th Amendment, banning poll tax as a bar to voting rights. 25th Amendment, death, removal, resignation, or incapacity of the President. 26th Amendment, voting age reduced to 18. And finally, the 27th Amendment, no pay increases for Congress until after the general election. I give each amendment its due in later chapters of this audiobook. Now, debating the need for judge-made law. Article 5 of the Constitution lays down pretty clear procedures for amending the Constitution, providing a choice of 4 routes. Isn't that enough? Or should the guardians of the law be allowed to make changes to the Constitution themselves? There are dissenting views on this. The objections to limiting constitutional change to the methods set out in Article 5 are as follows. First, the Article 5 procedures are cumbersome and slow. Secondly, as a result, we are stuck with a constitution that is largely the product of a bygone age. Third, the situation makes it difficult for the Constitution to respond to changes in society and politics. Also, the old-fashioned language of the Constitution has to be interpreted and made relevant to modern society. And finally, the U.S. Constitution is very well suited to making the Constitution relevant to modern society. On the other side are people who argue that we should stick to the proper Article 5 procedure for amending the Constitution. They believe that it is just plain wrong for judges to rewrite the Constitution, and here are some of their reasons. The Article 5 procedures ensure that changes to the Constitution are made only after due consideration and with wide support. Secondly, the principles enunciated in the Constitution are timeless. Third, the Constitution should not become the plaything of changing fashions. Fourth, the language of the Constitution does have to be interpreted, but that is not the same thing as changing its meaning. 5. If judges rewrite the Constitution according to their own predilections, this can only lead to disagreement over what the Constitution means. 6. The U.S. Supreme Court, made up of unelected judges, is not entitled to change the Constitution. And 7. It's simply undemocratic or even anti-democratic for judges to rewrite the Constitution according to their own likes and dislikes. Which of these 2 points of view is right? You're welcome to make up your own mind, but my own view is that it's wrong for judges to try to amend the Constitution. Sampling judge-made amendments. Here are a few examples of changes to the U.S. Constitution made by decisions of the Supreme Court. Privacy. In Griswold v. Connecticut, 1965, the Supreme Court discovered a right of privacy lurking in, quote, emanations, unquote, from the, quote, penumbras, which means the shadowy surrounds, of certain guarantees in the Bill of Rights. This was the only way in which the majority on the court could get over the serious problem identified by Justice Potter Stewart, which I actually quoted earlier, in his dissenting opinion, in which he said, "I can find no such general right of privacy in the Bill of Rights, in any other part of the Constitution, or in any case ever before decided by this court," unquote. Abortion. Justice Harry Blackmun, writing for the majority of the Supreme Court in Roe v. Wade in 1973, admitted that, quote, "the Constitution does not explicitly mention any right of privacy," unquote. However, he went on to say, "the court has recognized that a right of personal privacy does exist under the Constitution. This right of privacy," the majority on the court concluded, "includes a woman's right to terminate her pregnancy, an absolute right up to the end of the first trimester, which is weeks 1 to 12, and after that, when it's necessary to protect a woman's health." Justice Byron White, dissenting, condemned the majority decision as, quote, "an exercise of raw judicial power," adding, "I find nothing in the language or history of the Constitution to support the court's judgment," unquote. And even Justice Ruth Bader Ginsburg, a strong pro-choice advocate, has criticized Roe v. Wade as, quote, "heavy-handed judicial intervention," unquote, in an issue that should rather have been left to the democratic political process. Opposition to Roe comes chiefly from those who believe in the right to life of the unborn child. And it's also possible to argue that abortion should not just be a woman's right to choose, but should also involve the husband or father, whose right even to be notified was rejected by the Supreme Court in the case called Planned Parenthood v. Casey, 1982. Affirmative action. In the landmark case of Brown v. Board of Education, 1954, the Supreme Court ruled that racial segregation of students in public schools was unconstitutional because it violated the 14th Amendment, which prohibits states from denying anyone, quote, "the equal protection of the laws," unquote. Brown, like the 14th Amendment on which it was based, was concerned with equal rights. But when it failed to lead to racial equality, President John F. Kennedy issued an executive order, which is not supposed to change the law, requiring government employers to, quote, "take affirmative action," unquote, in selecting applicants for government posts. This marked the beginning of widespread affirmative action, especially in education. In the case called Regents of the University of California v. Bakke, 1978, the Supreme Court found the quota system operated by the university's medical school unconstitutional, while still allowing race to be taken into account in admissions. In 2007, in a case involving a Seattle and a Kentucky school district, Chief Justice John Roberts famously concluded his plurality opinion with the words, quote, "the way to stop discrimination on the basis of race is to stop discriminating on the basis of race," unquote. Or, as Justice Clarence Thomas put it, the Constitution is colorblind. The greatest victory against affirmative action to date came in a case called Schutter v. Coalition to Defend Affirmative Action in 2014, in which 6 justices of the Supreme Court upheld a Michigan initiative supported by 58% of voters, which amended the state constitution by banning affirmative action, with some exceptions, in the operation of public employment, public education, or public contracting. However, affirmative action is far from dead and was again upheld by the Supreme Court for university admissions in the second Fisher v. University of Texas case decided in 2016. Same-sex marriage. In Obergefell v. Hodges, 2015, the Supreme Court decided by a 5-4 majority that marriage is a fundamental constitutional right guaranteed to same-sex couples as much as to male-female couples. Chief Justice Roberts penned a strong dissent. Quote, "The majority's decision is an act of will, not legal judgment. The right it announces has no basis in the Constitution or this Court's precedent. The Court invalidates the marriage laws of more than half the states and orders the transformation of a social institution that has formed the basis of human society for millennia, for the Kalahari Bushmen and the Han Chinese, the Carthaginians, and the Aztecs. Just who do we think we are?" Unquote. Money in politics. Unlike all the other cases in this section I've been discussing, the case of Citizens United versus Federal Election Commission 2010 may be regarded as a conservative decision. It arose out of a challenge by a conservative non-profit organization called Citizens United to the McCain-Feingold Act of 2002, which prohibited corporations and labor unions from funding, quote, electioneering communications, unquote, within 30 days before a primary or 60 days before a general election. Citizens United wanted to air on TV an advertisement of its own political documentary titled Hillary the Movie during the 2008 Democratic Party presidential primaries. The majority opinion, written by Justice Anthony Kennedy, struck down McCain-Feingold as a violation of the First Amendment's protection of freedom of speech, which prohibits any restriction on political expenditure by corporations and labor unions. Enjoining the decision of the court, Justice Antonin Scalia claimed that there was no reason why the right of freedom of speech under the First Amendment did not include, quote, the freedom to speak in association with other individuals, including association in the corporate form, unquote. Justice John Paul Stevens concluded his robust dissent with the observation that the American people had, quote, fought against the distinctive corrupting potential of corporate electioneering since the days of Theodore Roosevelt. It is a strange time to repudiate that common sense. While American democracy is imperfect, few outside the majority of this court would have thought its flaws included a dearth of corporate money in politics, unquote. We're now on part 2 of the audiobook, We the People, How the United States is Governed. And chapter 6 is called Scrutinizing Sovereignty, Who Rules America? We the people rule the US of A, right? Well, maybe not. The president and a few other big hitters are involved too. Here are the main contenders for the title of ruler of the United States. First, we the people, then the president, then the Congress, then the states, then the U.S. Supreme Court, and lastly, organizations such as the Council on Foreign Relations, the Trilateral Commission, and the Bilderberg Conference. I'll have a look at the claims of each of these contenders in turn. My conclusion is that sovereignty is not held by any one single person or institution. Sovereignty is shared among the first 5 institutions that I have just mentioned. But that doesn't mean that all 5 institutions have an equal share. They do not. But the degree of dominance that any one institution enjoys at any one time varies in accordance with circumstances and with the personalities concerned. The phrase, we the people, entered history when it appeared in the preamble or introduction to the U.S. Constitution. The preamble is a fanfare proclaiming the nature and purpose of the Constitution. It doesn't form part of the Constitution as a legally enforceable instrument, but courts sometimes cite the preamble as evidence of the framers' intentions in drafting the Constitution as a whole. Does the use of the phrase "we the people" mean that the framers claimed to be establishing a democracy? Not at all. Ancient constitutions and legal systems claimed to have been handed down by a god, a king, or some semi-divine lawgiver. The framers tacitly rejected these models and claimed a popular basis for the U.S. Constitution. But that is not the same as claiming that the system of government established by that Constitution was a democracy. Indeed, neither the word democracy nor the word democratic figures anywhere in the text of the Constitution, as I've mentioned before. Ordaining and establishing a constitution. The preamble claims that we the people do ordain and establish this Constitution for the United States of America. Is this claim true? The Constitution was drafted by the Philadelphia Convention, made up of 55 delegates from 12 of the 13 states. Rhode Island refused to participate. The 55 delegates included most of the founding fathers of the nation, with the notable exceptions of John Adams and Thomas Jefferson, who were both serving in Europe at the time. Jefferson described the convention as an assembly of demigods, but regretted their decision to conduct their deliberations behind closed doors. Who picked these demigods? Not we the people. They were selected by the state legislatures, which in turn were elected. But only about 15% of the adult white male population had the right to vote. So we the people rings a bit hollow as far as the drafting of the Constitution is concerned. But we the people at least ratified, that is, confirmed the Constitution, right? Not exactly. Ratification was entrusted to a specially elected convention in each of the 13 states, except Rhode Island. So we the people had only an indirect say on ratification. Making democracy fashionable. The acceptability of democracy as a political ideal can be gauged from the use of the word democratic as a party political label. Historians often refer to the political party founded in 1791 by Thomas Jefferson and James Madison as the Democratic Republican Party, but in fact both Jefferson and Madison refer to themselves simply as Republicans and to their party as the Republican Party, down to 1823. That party, by the way, had nothing to do with the modern Republican Party. Adherents of the party of Jefferson and Madison were sometimes called Democrats, not by themselves, but as an insult by their opponents, who equated Democrats with Jacobins, the most extreme French revolutionaries. Ex-President George Washington himself said of a professed Democrat that he will leave nothing unattempted to overturn the government of this country. At the party's first national convention, held in 1832, it was still calling itself the Republican Party. It officially changed its name to the Democratic Party only in 1844. By this time, Democratic had become a positive political label, thanks largely to Andrew Jackson, who was instrumental in extending voting rights to all adult white males. The Constitution did not aim to establish a democracy. Instead, the framers were aiming to establish a republican form of government, which was not the same thing at all. I have discussed that already. Resolving to preserve democracy. The first 6 presidents were all members of a wealthy elite. The election of Andrew Jackson to the presidency in 1828 broke with that aristocratic tradition. Jackson was an unabashed populist. The first plank in the program of Jacksonian democracy was the extension of voting rights to all white men, sweeping away property qualifications. Jackson also repeatedly called for a constitutional amendment to abolish the electoral college system, which he saw as an undemocratic way of electing the president. But Jackson was no liberal. His populism extended only to the white population. He was himself a slave owner, and his belief in the manifest destiny of the United States to expand westward and control the whole of North America from the Atlantic to the Pacific Ocean resulted in a less than sympathetic attitude towards Native Americans. As a result of Jackson's two-term strong presidency, followed by the single term of the skillful Democratic Party organizer Martin Van Buren, and that of the much underrated James K. Polk, populist democratic ideals became widely accepted in the 1840s. What about Abraham Lincoln's vision of democracy? By the time of Abraham Lincoln, who was first elected president in 1860, democracy had become quite respectable. Lincoln concluded his famous Gettysburg Address with a solemn pledge that has echoed down the years. "We here highly resolve that these dead shall not have died in vain, that this nation, under God, shall have a new birth of freedom, and that government of the people, by the people, for the people, shall not perish from the earth." This is pretty heady stuff, but what exactly does it mean? Lincoln delivered his speech on November 19, 1863, just a few months after the bloody Battle of Gettysburg. The occasion was the dedication of the Soldiers' National Cemetery in Gettysburg, Pennsylvania. Lincoln didn't use the word democracy, but his three rhythmical phrases, government of the people, by the people, for the people, are commonly taken as a definition of democracy. Was Lincoln holding up democracy as an ideal for the future? Yes, but he also seems to have thought that it already existed. Indeed, the theme of his 2-minute address was that the cause of the Union in the Civil War was the cause of democracy. But did Lincoln really have the right to cast himself as the spokesman for democracy? His own election to the presidency in 1860 was anything but a landslide. Although he won a majority of electoral votes, he carried only 18 states out of 33 and got less than 40% of the popular vote. His election to the presidency was the most divisive in American history. When Lincoln was declared the winner of the 1860 presidential election, 7 southern states seceded even before his inauguration. Lincoln's identification with democracy also has another problem, because government by the people looks very much like direct democracy, which has never existed in the United States. Let's look at the word democracy a little more closely. The word democracy comes to us from the Greek demokratia, meaning the power of the people. But can the people ever rule themselves? Well, it did happen in ancient Athens, sort of. The citizens all met together in the ecclesia, or assembly, and deliberated, but only adult males had the rights of citizenship. Women, slaves, and resident aliens had no civic rights. Athens had about 30,000 citizens at its height, about 10% of the population. Athenian democracy was direct democracy. That form of government would be impossible in the United States today, with a population of around 325 million. Instead, the type of democracy that exists now is indirect, or representative democracy, in which the people don't run the government themselves, but pick other people to do it for them. So how does an indirect democracy stand up to Lincoln's 3-part test? Government of the people. This is ambiguous. Does it mean that the people are doing the governing, or that they are being governed? If the former, then it's the same as government by the people. If the latter, then it could apply to any form of government. Any government is automatically a government of the people in that sense. It doesn't have to be a democratic form of government. A monarchy, a dictatorship, an oligarchy, all are governments of the people, but they certainly aren't governments by the people. Now we come to the phrase government by the people. This is the elusive one. Government by the people, in the sense of direct democracy, has never existed in the United States, and could never exist. So what was Abe Lincoln thinking of? Or did he just figure that it had a nice ring to it as part of a threesome? And then government for the people. Every government of every kind everywhere in the world always maintains that it governs in the interest of its people or for the people. This is not a specifically democratic feature at all. In fairness to Abe, he probably figured that the sort of indirect representative democracy that we have in the United States was actually government by the people. A pretty dangerous assumption to make by a guy who got into the White House with just 39.8% of the popular vote. However, he did become popular enough to make it onto the $5 bill, and the penny, of course. Perhaps being outspoken has its advantages. But what about today? Is the United States a true democracy in the 21st century? Yes and no. Here are some points in favor of and against classifying the United States as a democracy. First of all, everybody 18 years or older has the right to vote. Yes, but the voters are usually presented with a choice of one out of only two candidates, if that. The really important election often is not the general election, but the Democratic or Republican primary. Secondly, voters can also pick the candidates for the political party of their choice by participating in the primaries. Yes, but the choice in primaries is usually among a bunch of millionaires or candidates bankrolled by political action committees, PACs as they're often called, funded by corporate money. Third, office holders are mostly restricted to comparatively short terms, like 4 years for the president and 2 years for members of the House of Representatives. Although presidents are limited to 2 elected terms, representatives and senators can be re-elected indefinitely, and quite often are. More posts are filled by popular election than in most other countries. This is another argument, often including state judges, mayors, school boards, and, previously, even dog catchers. Yes, but most elective positions are at the state level. It's perhaps a pity that federal judges are not elected as well. Another point is popular or citizens' initiatives, propositions, or referenda are the closest thing in the United States today to ancient direct democracy. They allow the voters a direct say in no fewer than 24 states plus the District of Columbia. Yes, but initiatives are just votes on specific issues, which is a far cry from decision-making on a day-to-day basis. Also, initiatives exist purely at the state level. Moves to allow national initiatives have never gotten very far. Another point in favor of the United States being a democracy today, the United States has a healthy two-party system that guarantees competition. Yes, but quite a number of districts, and even whole states, are routinely in either the red or the blue column. Lastly, the views represented in U.S. political institutions span a wide range. Yes, but third parties and independents have little chance of being elected, largely because of the winner-take-all electoral system. So, do we the people rule the roost? No, because the power of the people is indirect, and it can also happen, as in 2016, that someone can be elected president with a majority of electoral votes, but a minority of the popular vote. Yet we the people must certainly be regarded as having some share of sovereignty at least. Now let's turn to the power of the President, the next contender for power dominance. I examine his position in more detail in Chapter 10. Hailing the Chief. The President of the United States is commonly said to be the most powerful person in the world. But how much power does he exercise in the United States itself? From the beginning, critics of the Constitution were afraid that the President would become too monarchical. For example, Patrick Henry, the radical revolutionary, characterized the Constitution as squinting towards monarchy. To counter these fears, George Washington discouraged people from addressing him as Your Excellency, preferring the more Republican appellation, Mr. President. The framers were careful to incorporate into the Constitution the principle of the separation of powers, coupled with a system of checks and balances. The purpose of this arrangement was to prevent any one of the three branches of government, executive, legislative, and judicial, from becoming too powerful. Here are the points in favor of and against regarding the President as sovereign. First, the President combines the position of head of state with executive power, so his dominance over the federal government is guaranteed. Not so. Periods of strong presidential power have alternated with periods when the President was pretty insignificant compared to Congress and the Supreme Court. Abraham Lincoln was a strong president, but the presidents who preceded and succeeded him were mostly pretty weak. After the strong presidencies of Theodore Roosevelt and Woodrow Wilson, Congress became dominant again until the so-called imperial presidency of Franklin D. Roosevelt. In 1973, Watergate dealt a severe blow to presidential power, but Ronald Reagan put the presidency on a strong footing again, which benefited Bill Clinton, George W. Bush, Barack Obama, and Donald Trump. The second point in favor of the president being regarded as sovereign is the president has control over foreign affairs and defense, especially in times of war. The answer to that is, well, sure, but the War Powers Act allows Congress to limit presidential war powers. The Senate also has the power to block presidential appointees, and the Supreme Court can clip the president's wings too, as happened with President George W. Bush in regard to Guantanamo Bay and with Donald Trump over his travel ban, though that was later agreed. Another point in favor of the president being regarded as sovereign is the president can veto bills that have passed Congress, and a presidential veto can be overridden only by a two-thirds majority in both houses of Congress. True, but vetoes can backfire, as President Bill Clinton found out when his deadlock with Congress over the budget twice paralyzed the federal government for months. At the present time, the power of the president is great, but certainly not unchallenged. A particular sharp thorn in the side of President Trump is the appointment of Bob Mueller III as special counsel with the power to investigate the president without the president having the direct power to fire him. Let me turn now to Congress and its claim to sovereignty. In 1884, when a young Woodrow Wilson wrote a book about the U.S. constitutional practice, he titled his book Congressional Government. He wrote, quote, "The actual form of our present government is simply a scheme of congressional supremacy," unquote. Nobody could write that today, and Wilson himself actually turned out to be a strong president, although he was thwarted by Congress in regard to his pet project, the League of Nations, which was a forerunner of the United Nations, which the US never joined. The President can veto any bill passed by both houses of Congress, but that veto can be overridden by a two-thirds majority in both houses. This overriding has occurred comparatively rarely. Here is a rundown of the situation since 1981, when Ronald Reagan entered the White House. Under Barack Obama, Congress overrode President Obama's veto of the Justice Against Sponsors of Terrorism Bill of 2016, which allowed families of victims of the 9/11 terrorist outrage of 2001 to sue Saudi Arabia. This was the only time that an Obama veto was overridden. George W. Bush. Congress overrides President George W. Bush's veto of the Medicare Improvement for Patients and Providers Bill, 2008. This was one of 4 of George W.'s vetoes that were overridden by Congress. Bill Clinton. Congress overrides Clinton's veto of the Private Securities Litigation Reform Bill of 1995, which was designed to limit frivolous lawsuits. Clinton's veto was overridden on only one other occasion. George H.W. Bush. Congress overrides his veto of the Cable Television Consumer Protection and Competition Bill, 1992. This was the only override of a veto by President Bush 41. Ronald Reagan. Congress overrides his veto of the Comprehensive Anti-Apartheid Bill of 1986, which imposed sanctions on South Africa. This was one of 4 of Reagan's vetoes that were overridden by Congress. But the conflict between the President and Congress pales into insignificance by comparison with the conflict between the Supreme Court and the other 2 branches of government. Now let's look at the states in their claim for sovereignty. Do the states have a share in the sovereignty of the United States? Absolutely. The history of the United States could easily be written in terms of the tensions between state and federal power. Incorporation is the key issue in the relationship between the states and the feds. The question of how much of the Bill of Rights applies to the states as well as to the federal government. Why is this called incorporation? Because the question is whether the Bill of Rights, or any part of it, is incorporated into the 14th Amendment by one of 3 provisions of that amendment: A, the Due Process Clause, B, the Privileges or Immunities Clause, and C, the Equal Protection of the Laws Clause. After many twists and turns, the U.S. Supreme Court now recognizes the whole of the first 8 amendments as applying to the states as well as to the federal government, with only 2 small exceptions: the 5th Amendment provision for indictment by a grand jury and the 7th Amendment right to a jury trial in civil lawsuits. In other words, these 2 features are left to the states. Currently, only about half the states use grand juries for indictments, but jury trials are available at the request of either party in a civil suit in every state except Louisiana. Other important claims of the states to sovereignty would include state sovereign immunity, a very important question which I deal with in Chapter 7, and also, in regard to presidential elections, the national popular vote actually takes second place to the state-based electoral college system. The winning candidate needs a majority of electoral votes with or without a majority of the popular vote. For example, in 2016, Donald Trump was elected president with a majority of electoral votes, but a minority of the popular vote. I'll get back to that in Chapter 10. Power of the states also dealt with in Chapters 7 and 20. Now what about the Supreme Court, their claim to sovereignty, saying what the law is? The Supreme Court certainly deserves to be up there with the President and the Congress as a sharer in sovereignty. This idea would have come as a shock to the framers. The Constitution establishes the principle of the separation of powers, in which the three branches of government, executive, legislative, and judicial branches, are all equal, and each acts as a check and balance against the others. However, one of the leading framers of the Constitution, Alexander Hamilton, was convinced that, with separation of powers, the judiciary, quote, will always be the least dangerous, unquote, to the other two branches of government, because it lacked either the power of the sword or the power of the purse. From a present-day vantage point, Hamilton's view of the judiciary as a shrinking violet seems almost laughable. For example, Hamilton spoke of the power to, quote, prescribe the rules by which the duties and rights of every citizen are to be regulated, unquote. This is a perfect description of one of the many powers exercised by the Supreme Court. But Hamilton attributed it to Congress. Hamilton wrote the words that I have just quoted in 1788. He could not have known how completely the role of the Supreme Court was to be transformed by Chief Justice John Marshall, who held office from 1801 to 1835. In the famous case of Marbury versus Madison, decided in 1803, Marshall said, "It is emphatically the province and the duty of the judicial department to say what the law is." These words are so important and so often quoted that they can now be seen inscribed on the wall of the Supreme Court building behind John Marshall's statue. But where in the Constitution does it say that the Supreme Court has this huge power? Nowhere. So where did Marshall get this idea from? It was one of his many twistifications. Thomas Jefferson's word to describe the way in which Marshall's mind worked. And Jefferson ought to have known, as the two men were distant cousins and lifelong foes. Jefferson, the third president, recognized the danger of judicial activism. He wrote these words during his presidency in 1804, the year after Marbury versus Madison. Quote, "But the opinion which gives to the judges the right to decide what laws are constitutional and what not only for themselves in their own sphere of action, but for the legislature and executive also in their spheres, would make the judiciary a despotic branch, unquote." Charles Evans Hughes, Chief Justice from 1930 to 1941, famously said, as I've quoted several times before, "We are under a constitution, but the constitution is what the judges say it is," unquote. This looks like a cynical recognition of the power of the Supreme Court, but Hughes then went on to say, "And the judiciary is the safeguard of our liberty and our property under the Constitution." So he recognized the power of the judges, but he saw it as a power for good. It's impossible to disagree with Hughes' assessment of the power of the Supreme Court, but not everyone would agree with his characterization of that power as benign. I deal with the judiciary in Chapter 12, and in Chapter 5 I list a few of the ways in which the U.S. Supreme Court has amended the Constitution without being permitted to do so under the Constitution, which lays down a very specific and quite elaborate procedure for amending the Constitution that does not involve the courts at all. Now, let's lastly look at conspiracy theories. Conspiracy theories have been around forever. Any organization or group of people that was a bit separate from the rest of society, a bit different, or a bit secretive, was likely to find itself targeted as holding the controlling power behind the scenes. The theory behind this kind of thinking is that the Constitution is just a front for the exercise by some group or groups. Groups that have been targeted in this way include the Jews, the Catholic Church, and the Freemasons. 3 associated organizations, the Council on Foreign Relations, the Trilateral Commission, and the Bilderberg Conference, have been attacked in recent years as being the secret power brokers not only over the United States, but also internationally. So let's have a look at these organizations, because there is this theory that they pull the strings behind the scenes. Council on Foreign Relations, the private US-based organization established in 1921 and dedicated to a study of foreign policy. Its members include Republicans, Democrats, and Independents. It's widely believed to have had considerable influence on U.S. foreign policy, including the normalization of relations with Red China. The Trilateral Commission is a private association of about 350 members, established in 1973. The idea behind it was to develop closer economic cooperation between North America, Europe, and Japan. Its membership is said to include former Secretary of State Henry Kissinger, former U.S. Presidents Jimmy Carter and the late George H.W. Bush, and Bill Clinton, former Vice President Dick Cheney, and Senator John McCain. Lastly, the Bilderberg Group, sometimes called club or conference, is the strangest of the 3 associated organizations, as its 130 members meet only once a year. The group was founded in 1954 to counter growing anti-American sentiment in Western Europe by fostering mutual understanding between Europe and the United States. There are generally 2 invitees from each participating nation, 1 conservative and 1 liberal. The membership of this club overlaps to quite a marked extent that of the Trilateral Commission, and to some extent also that of the Council on Foreign Relations. The membership of the 3 organizations includes a lot of influential names. But are they influential because of their membership, or are they members because they were already influential? The latter seems to be the case. The 3 organizations have been accused of aiming to establish a single world government, or New World Order, in which the United States would lose its separate identity and become absorbed into an international state ruled by a small elite. But if that is the plan, it doesn't appear to have made much headway so far. Chapter 7. Defining Federalism. The United States has a federal system of government, right? Right. Anytime somebody doesn't like what the federal government is doing, he or she blames the feds. And when you come across a government acronym starting with the letter F, chances are it stands for federal. Think FBI, FCC, FDIC. The United States has a federal system of government, but the word federal doesn't figure anywhere in the text of the Constitution. This fact raises some pretty important questions, which I'll deal with one by one. What is federalism, first of all? How do we know that the United States has a federal system of government, and has United States federalism changed over time? And if so, how? Let's look at the origins of federalism in the U.S. A federal system of government is one in which power is shared between the federal government, which is the central or national government, and the state, provincial, or regional governments. The United States is the oldest federal nation in the world, but it sure isn't the only one. Just a few of the other countries that also have federal systems of government are Argentina, Australia, Austria, Brazil, Canada, Germany, India, Mexico, and Nigeria. Let's go back to the founding documents to have a look at that. The United States began life as 13 separate British colonies, which united in opposition to their treatment by the British government of the day, particularly against the imposition of taxes by the British Parliament, on which the American colonies were not represented. This opposition was expressed in the well-known slogan, "No taxation without representation." The Declaration of Independence. The Declaration of Independence of July 4, 1776 was headed, "The Unanimous Declaration of the 13 United States of America." We are now used to using the term the United States of America as referring to one single country, but that phrase didn't have the same meaning back in 1776, as can be seen from a close reading of the text of the Declaration. The concluding part of the Declaration is particularly revealing. It declares, quote, that these united colonies are, and of right ought to be, free and independent states, and that as free and independent states they have full power to levy war, conclude peace, contract alliances, establish commerce, and to do all other acts and things which independent states may of right do, unquote. The Declaration of Independence is commonly taken to mark the beginning of the existence of the United States of America as a nation. The Declaration certainly severed all ties with Britain, but it did not create a single new country. Instead, it created 13 separate new countries. Notice that the language of the Declaration is all in the plural. The key to its meaning lies in the last sentence that I've quoted. Each of the states, says the Declaration, has the power to make war and peace. And the end of the quoted passage contains an assertion that the 13 colonies are independent states, plural. The Articles of Confederation, passed by Congress in 1777 and formally ratified in 1781, served as the Constitution of the United States from 1777 until 1788. A confederation is a weaker form of association between states than a federation. The best-known confederation is Switzerland, although even that has since 1848 been a federation rather than a confederation, but with a very weak, almost non-existent, central government. Power resides in the governments of the 26 cantons that together form the Swiss Confederation. The American Articles of Confederation recognize the sovereignty of each of the 13 states. Article 2 of this document made the position quite clear. Each state retains its sovereignty, freedom, and independence, and every power, jurisdiction, and right which is not by this confederation expressly delegated to the United States in Congress assembled. The Congress was the only central institution established by the Articles of Confederation. The Congress was not an elected body, but was made up of delegates appointed by each of the state legislatures for a year at a time. Congress had power only over foreign affairs and defense. The Articles of Confederation did not establish any form of central executive power or any national courts. The Articles established not a single country, but merely a firm league of friendship among the 13 sovereign states. The form of government set up under the Articles of Confederation was hopelessly weak, and conflicts among the states arose. George Washington and some other leading figures recognized the need for a new constitution to form a more perfect union. So a grand convention, as it was called to meet in Philadelphia in May 1787. Its original purpose was to revise and amend the Articles of Confederation, but the convention ended up drafting a whole new instrument of government, the U.S. Constitution. The first printed draft of the Constitution, dated August 6, 1787, is significantly different from the final version approved by the Convention only a few weeks later, on September 17, 1787. Instead of the now familiar "We the people of the United States" in the preamble, the earlier draft had a list of all the states. "We the people of the states of New Hampshire, Massachusetts, Rhode Island, and Providence Plantations, Connecticut, New York, New Jersey, Pennsylvania, Delaware, Maryland, Virginia, North Carolina, South Carolina, and Georgia, do ordain, declare, and establish the following Constitution for the government of ourselves and our posterity." The change from this formulation to "We the people of the United States" signals a last-minute shift in emphasis from the states to the national government. However, both versions of the Constitution assert the supremacy of the U.S. Constitution and federal law over the state constitutions and laws. In the final version of the Constitution, this fundamental principle is found in the so-called Supremacy Clause in Article 6, which I've referred to before. Does the Supremacy Clause mean that the federal government can simply ride roughshod over the states and do whatever it likes? No. The Supremacy Clause gives supremacy to the federal or union government, subject to the limits imposed upon it by the Constitution. But the Constitution is not at all clear about the status of the states and their relationship with the federal government. Above all, are the states sovereign? And what is the meaning of sovereignty anyway? Let's consider that. Define sovereignty. A sovereign state is one that has complete legal independence. For example, the United Kingdom is a sovereign state, but Scotland is not. Scotland forms part of the United Kingdom and enjoys a high degree of autonomy or self-rule, but Scotland does not have complete legal independence. The United States started out as 13 British colonies that declared themselves individually independent as 13 sovereign states. In 1777, these 13 sovereign states banded together under the Articles of Confederation, which recognized each of the states as sovereign. This loose association of sovereign states didn't work out too well, which is why the U.S. Constitution was created. But the Constitution didn't directly address the question of whether the 13 states were still sovereign, or whether they had surrendered some of their independence to the federal government. A sovereign state automatically enjoys sovereign immunity, meaning that it cannot be prosecuted for any crime or sued in a civil court unless the sovereign state itself gives permission for that to happen. That's why cars belonging to the representatives of foreign nations can ignore parking tickets, a serious problem in Washington, D.C. and New York City. Are the states of the United States sovereign? And do they enjoy sovereign immunity? The 11th Amendment, which was intended to settle this issue, can be interpreted in 4 different ways. The most generally accepted, though vague, answer to these tricky questions is that the states are not sovereign in the fullest sense of that term, and that they therefore enjoy only partial immunity from suit. Say more about that in Chapter 20. Can a state secede from the Union? Can a state lawfully secede from the United States of America? The Constitution doesn't provide an answer to this crucial question. When 11 southern states did in fact secede in 1860-61 and constituted themselves into the Confederate States of America, or the Confederacy, as it's commonly known, their action was condemned as rebellion, and a bloody civil war ensued. In the case of Texas versus White, 1869, the Supreme Court declared secession to be unconstitutional, but the authority of that decision is now questioned in some quarters. Chief Justice Chase, who wrote the majority opinion, was anxious to rule that secession was unconstitutional, and it's easy to see why. Firstly, the year was 1869, and Texas and the other secessionist states were in the throes of Reconstruction. Secondly, Chase himself had been Secretary of the Treasury in Lincoln's cabinet. And thirdly, Chase and 4 other justices who sat on the case of Texas versus White were Lincoln appointees. So, did the Supreme Court have an ulterior political motive for declaring that secession was unconstitutional? You betcha. Let's test state sovereignty through some recent Supreme Court decisions. Just when it may have looked as though the problems about states' rights had been laid to rest, a flurry of blockbuster cases came before the courts that all went to the heart of federalism. First of all, Shelby County versus Holder, which is about the Voting Rights Act. Decided in 2013, the Supreme Court struck down as unconstitutional a provision of the Voting Rights Act of 1965 on the ground that it conflicted with the constitutional principles of federalism and, quote, equal sovereignty of the states, unquote. The offending provision of the 1965 Act required certain states to obtain what was called pre-clearance from the U.S. Attorney General or the U.S. District Court for the District of Columbia that any proposed change to their voting laws or practices did not discriminate against protected minorities. The states in question were 9, mostly southern states, plus 7 component parts of states, selected on the ground that they had discriminated by means of poll taxes and literacy tests. In Shelby County versus Holder, the U.S. Supreme Court, in a 5-4 decision, effectively disbanded the whole pre-clearance system. The majority was made up of the 4 conservative justices plus Justice Kennedy, with the liberal members of the court dissenting. Chief Justice Roberts, for the majority, pointed out that the pre-clearance provisions did not treat all states equally, as was required, but discriminated against certain, mostly southern, states. Then, to do with voter ID, the ruling in Shelby means that challenges to changes in electoral law in the states previously covered by the pre-clearance system now have to be decided on a case-by-case basis. The current bone of contention concerns voter ID, which is an issue controlled by the states. Conservatives tend to favor photo ID as a voting requirement, while some liberals oppose it as discriminatory of minorities and the poor. Surprisingly, perhaps, a 2005 bipartisan report by a commission headed by ex-President Jimmy Carter recommended that voter ID be made mandatory and that eligible voters would be issued free photo ID cards. This sensible proposal has never been implemented. However, in Crawford versus Marion County Election Board 2008, the Supreme Court, by 6 votes to 3, upheld as constitutional an Indiana law requiring photo ID for voting, but also allowing those unable to afford a photo ID to vote if they executed a sworn affidavit to that effect, although Indiana's ID cards are free. Interestingly enough, the leading opinion was written by Justice John Paul Stevens, who is generally thought of as a liberal. Yet objections to photo ID for voting continue to be voiced. Individual states have enacted various voter ID qualifications, some requiring photo ID, others requiring non-photo ID, with some being stricter and others less strict, and no fewer than 18 states plus Washington, D.C., requiring no ID at all in order to vote. Public opinion is broadly supportive of voter ID. A 2012 Pew poll showed an overall majority of 77% in favor of photo ID, made up of 95% of Republicans, 83% of independents, and 61% of Democrats. Those favouring photo ID are chiefly concerned with preventing voter fraud, while those opposing it tend to regard the requirement of a photo ID as discriminating against minorities and the poor. The most common form of voter ID is a driver's license, which minorities and the poor are less likely to have. However, in most states, it's possible to obtain a non-driver ID card from the Department of Motor Vehicles upon payment of a small fee. $29 in California, $13 in New York. What about the danger of voter fraud, which is another issue affecting the states which control and administer voting in elections? This issue was highlighted by President Trump's claim that between 3 and 5 million votes cast in the 2016 presidential election were illegal. This extreme claim was probably motivated by Trump's peak at losing the popular vote to Hillary Clinton by almost 3 million votes. The idea of widespread voter fraud has been widely pooh-poohed, even by a number of Republican office holders. In May 2017, President Trump issued an executive order creating a Presidential Advisory Commission on Election Integrity. Yet 44 states, plus the District of Columbia, have refused to play ball, some declining to give any information and others agreeing to give only partial information to the Commission. The issue of voter fraud certainly raises emotions on both sides. In the 1960 election, which put John Kennedy into the White House, rumors of vote rigging were rife, particularly in Texas and Cook County, Illinois, where Mayor Daley of Chicago ran a very efficient Democratic Party machine. Recounts revealed very few irregularities, but the type of voter fraud that was widely believed to exist would not have been revealed on a recount, consisting as it did in the impersonating of dead voters. As the conservative-leaning Chicago Tribune put it, once an election has been stolen in Cook County, it stays stolen. In regard to the 2016 election, former New York Mayor Rudy Giuliani, of the Republican Party, remarked, quote, "Dead people generally vote for Democrats rather than Republicans," unquote, because the inner cities tend to be controlled by the Democratic Party. And he continued, quote, "So what they do is they leave dead people on the rolls and then they pay people to vote as those dead people 4, 5, 6, 7, 8 times. Maybe if Republicans controlled the inner cities, they'd do as much cheating as Democrats," unquote. Because of President Trump's allegations of voter fraud, the 2016 election has proved particularly controversial, but a 2012 report by the Pew Charitable Trust, based on research conducted by RTI International, a non-profit, non-partisan research institute, found that, first, approximately 24 million, 1 of every 8 voter registrations in the United States, are no longer valid or are significantly inaccurate, unquote. Secondly, more than 1.8 million deceased individuals are listed as voters. And thirdly, approximately 2.75 million people have registration in more than one state. Of course, these figures don't equate to fraudulent voting statistics, but do reveal the wide scope of opportunities for voter fraud. The same report also highlighted the fact that at least 51 million citizens, or more than 24% of the eligible population, appeared, quote, to be unregistered in the United States, unquote. It's important to note that the whole issue of voter registration and ID is a matter for the states. Now there's the issue of immigration. The issue in the case of Arizona versus United States 2012 was whether a state law usurped the federal government's authority to regulate immigration. The U.S. Supreme Court struck down the most sensitive sections of the state law in question, with Justice Kennedy writing the majority opinion with the support of the supposedly liberal justices. The background to the case is as follows. Arizona, a state bordering on Mexico, has long had a problem with illegal immigration. In 2010, it had approximately 460,000 undocumented migrants, a five-fold increase since 1990. In January 2010, the Arizona state legislature began considering tough new measures. The killing of Robert Krentz and his dog close to the Mexican border in March 2010 gave the legislation an extra impetus. In April 2010, the Arizona legislature passed the law commonly referred to as SB 1070, which had widespread support among voters in the state. One of the most controversial sections made it a misdemeanor to work or seek work without proper authorization. Another such section allowed the arrest without warrant of foreigners believed on the basis of probable cause to be removable from the United States. Governor Jan Brewer of Arizona characterized the dispute as being, quote, about the fundamental principles of federalism, under which every state has a right to defend its people, unquote. But the case was decided under the Supremacy Clause, which is Article 6, Clause 2 of the Constitution, which gives the federal government what Justice Kennedy described as broad and undoubted authority to regulate immigration and aliens. The offending sections of the state law were struck down as being preempted by federal law. Justice Antonin Scalia, dissenting, rejected this whole argument on the basis of state sovereignty. Quote, as a sovereign, Arizona has the inherent power to exclude persons from its territory, subject only to those limitations expressed in the Constitution or constitutionally imposed by Congress. That power to exclude has long been recognized as inherent in sovereignty, unquote. Another very controversial area is Obamacare. The Patient Protection and Affordable Care Act, or the Affordable Care Act, ACA, nicknamed Obamacare, was a federal statute signed into law by President Obama in 2012. One of its most important and controversial provisions was the so-called individual mandate, requiring everybody, with the exception of those covered by an employer-sponsored health plan, Medicaid, Medicare, or some other public insurance program, to buy insurance or pay a penalty for refusing to do so. 28 states challenged the individual mandate in court and also objected that by requiring Medicaid expansion, the law placed an unfair financial burden on state governments. These challenges culminated in the U.S. Supreme Court case of Florida versus U.S. Department of Health and Human Services, consolidated with National Federation of Independent Business versus Sebelius 2012. In the Supreme Court, the states won on the Medicaid issue. The federal government defended the individual mandate on the basis of the powers of Congress under the Commerce Clause, or alternatively under the Necessary and Proper Clause. These arguments failed, but by 5 votes to 4, the Supreme Court upheld the individual mandate on a completely different basis altogether, as an exercise of Congress's taxing power. Chief Justice Roberts, writing for the majority, explained, quote, "The Affordable Care Act's requirement that certain individuals pay a financial penalty for not obtaining health insurance may reasonably be characterized as a tax. Because the Constitution permits such a tax, it's not our role to forbid it or to pass upon its wisdom or fairness," unquote. However, in the year 2018, there has been an attack by some courts on the constitutionality of Obamacare generally, and it remains to be seen how that is resolved. The case may well end up again before the Supreme Court. Same-sex marriage. Marriage doesn't figure in the Constitution, and it has traditionally been left to the states. But challenges to state laws about marriage can end up in the U.S. Supreme Court. Same-sex marriage has aroused the most recent controversy. In Obergefell v. Hodges 2015, the Supreme Court decided by 5 votes to 4 that the right to marry is guaranteed by the Constitution to same-sex couples as much as to male-female couples, and that state laws banning same-sex marriage violated the due process and equal protection clauses of the 14th Amendment. The majority opinion, written by Justice Kennedy and supported by the so-called liberal wing of the court, placed same-sex marriage on a broad constitutional foundation, declaring that, quote, "The Constitution promised liberty to all within its reach, that the fundamental rights embodied in the 14th Amendment's Due Process Clause, quote, extend to certain personal choices central to individual dignity and autonomy," unquote, and that this extension includes a right to marry. Justice Scalia, in a scathing dissenting opinion, which I've already referred to, attacked the majority opinion as, quote, lacking even a thin veneer of law, unquote, and descending, quote, to the mystical aphorisms of the fortune cookie, unquote. Let's turn now to foreign affairs, looking at the influence of treaties. Remember the first part of the Supremacy Clause, where it states, "The Constitution and the laws of the United States, which shall be made in pursuance thereof, and all treaties made, or which shall be made, under the authority of the United States, shall be the supreme law of the land." It may seem strange to find international treaties up there above state law, as part of the supreme law of the land. And the 1920 U.S. Supreme Court decision in Missouri v. Holland, which upheld the constitutionality of the Migratory Bird Treaty Act of 1918, has been characterized as meaning that, quote, the protection of an international duck takes precedence over the constitutional protections of American citizens, unquote. The leading authority on this question is still the Supreme Court decision in Reed v. Covert, 1957, in which the court held that, quote, no agreement with a foreign nation can confer power on the Congress or on any other branch of government which is free from the restraints of the Constitution, unquote. In Medellin v. Texas, 2008, the court held that an international treaty is not binding on domestic federal or state law unless Congress has enacted a statute to implement it, or unless the treaty itself is self-executing. Who has the power to make an international treaty? Article 2, Section 2, Clause 2 of the Constitution gives that power to the President, quote, by and with the advice and consent of the Senate, provided 2/3 of the senators present concur, unquote. there have been some exceptions to this rule, notably NAFTA, the North American Free Trade Agreement, which was ratified by being passed as an act of Congress and signed into law by President Clinton in December 1993. Of course, there have been some developments on that front under President Trump. For more on this, listen to Chapter 10. Perhaps even more importantly, who has the power to repeal a treaty? As a treaty once agreed automatically becomes part of U.S. federal law, Congress can repeal it in the same way as any other legislation, with presidential approval. But can the president repeal a treaty unilaterally without congressional approval? Amazingly, there is no Supreme Court ruling on this, although several presidents have taken it upon themselves to pull the U.S. out of an international treaty. When President Jimmy Carter unilaterally terminated a defense treaty, his authority to do so was challenged by Senator Barry Goldwater and other members of Congress, but the Supreme Court declined jurisdiction and dismissed the case without hearing oral argument, on the ground that it was a political question. Similarly, when President George W. Bush unilaterally withdrew the U.S. from the Anti-Ballistic Missile Treaty, which had been in force since 1972, the courts again declined to interfere. Right at the start of his term, President Donald Trump pulled the U.S. out of the 12-nation Trans-Pacific Partnership, and he has also withdrawn from NAFTA and renegotiated it with Canada and Mexico, and has withdrawn also from the Paris Climate Change Accords. Chapter 8. Separation of Powers, Checking and Balancing. The separation of powers is one of the fundamental principles of the U.S. Constitution, right up there with federalism, democracy, the rule of law, and judicial review. And like these other principles, the separation of powers is not specifically mentioned in the text of the Constitution. But what exactly is the meaning of separation of powers? At its simplest, this doctrine refers to separation between the three branches of government: the legislative branch, which is Congress, the lawmaking branch of government, the executive, which is the President, who has the duty under Article 2, Section 3 of the Constitution to, quote, take care that the laws be faithfully executed, unquote, and the judicial branch, the Supreme Court justices and other judges who interpret and enforce the law through the courts. Now, we have to examine the separation of powers from four different angles. First of all, the membership of the three branches of government. Secondly, the functions of the three branches. Thirdly, the purpose of separation of powers. And lastly, checks and balances between the three branches. I'll go through each of these in turn. But first, I'll trawl the text of the Constitution for any cryptic references to separation of powers. No moonlighting for the President. Although the Constitution never uses the phrase separation of powers, it does contain some oblique references to that principle. This fact is significant because it shows that separation of powers was embedded in the Constitution from the beginning, but the framers took the principle for granted. Here are the references to separation of powers in the Constitution. First of all, Article 1, Section 1 gives Congress, quote, all legislative powers under the Constitution. That means that the other two branches of government are not allowed to be involved in legislation. In reality, they both are involved, as you see when you examine the workings of checks and balances. Article 3, Section 1 similarly reads, quote, "The judicial power of the United States shall be vested in one Supreme Court and in such inferior courts as the Congress may from time to time ordain and establish," unquote. Although this section doesn't say all judicial power, the phrase "the judicial power" makes it clear that the courts are to have all judicial power, excluding the other two branches of government from judicial activities. Thirdly, Article 2, Section 1 forbids the President from receiving any payment from the United States or any of the states besides his salary as President. This means that the President isn't allowed to moonlight as a senator or a judge. Here's the actual wording, quote, "The President shall, at stated times, receive for his services a compensation, and he shall not receive within that period any other emolument from the United States or any of them," unquote. Emolument just means payment. President Donald Trump waived the presidential salary of $400,000, but his failure to divest himself fully of his properties and hand them over to a blind trust could possibly cause him trouble. For example, if it can be shown that certain policies of his, like, for example, his executive order repealing environmental protection for wetlands, benefit him financially as a real estate developer and golf course owner. The President is exempt from the conflict of interest statutes that are applicable to other office holders, but there's a general unwritten principle against using public office for private gain. Next, Article 1, Section 9, the Emoluments Clause, says that no U.S. government official, quote, "shall, without the consent of the Congress, accept of any present, emolument, office, or title of any kind whatever from any king, prince, or foreign state," unquote. This clause was incorporated into the Constitution after the King of France gave Benjamin Franklin a diamond-studded snuff box. It was then mostly forgotten, and the U.S. Supreme Court has never addressed it. President Obama's $1.4 million Nobel Prize wasn't a problem because it didn't come from a government source. Interest in this obscure clause was reawakened by the election of Donald Trump with his vast international business empire. Some even suggested that the very existence of the Trump International Hotel, situated at 1100 Pennsylvania Avenue, less than a mile down the road from the White House, might itself fall foul of the Emoluments Clause, acting as it does as a powerful magnet for foreign dignitaries visiting Washington, D.C. But nothing has happened since several failed attempts to take President Trump to court for infringing on the clause. Now let's have a look at the origins of separation of powers. The framers of the Constitution constantly had before their eyes the examples of Britain and Europe. They adopted what they liked from these systems, modified the features that they thought needed tweaking, and rejected the rest. In France, Spain, and other so-called absolute monarchies, a great deal of power was concentrated in the hands of the king. King Louis XIV of France famously remarked, "I am the state. L'État, c'est moi." The American founding fathers greatly admired the writings of Baron Montesquieu, an 18th century French aristocrat who praised the British Constitution for its supposed separation of powers. In fact, Montesquieu had an exaggerated impression of the degree of separation of powers that actually existed in the British Constitution. The framers of the U.S. Constitution had no first-hand experience of the workings of the British Constitution. They simply accepted Montesquieu's analysis of the British Constitution together with his theoretical framework. Keeping the branches apart. Would it be possible to have strict separation between the members of the three branches of government without strict separation of functions? Yes, it would, and that is the case with the U.S. Constitution. For example, the President can never be a member of the legislature or of the judiciary, but he does exercise some legislative functions and actually appoints the federal judiciary. To be more precise, the President nominates the federal judges who must be confirmed by the Senate. If they are confirmed, the President appoints them as federal judges. We'll have a look now at the membership and functions of each branch of the U.S. government. Membership, first of all. Separation of powers is strictly observed in regard to membership of the three branches of government. First, no member of the legislature, that is Congress, is allowed to hold an executive position at the same time. No member of Congress is allowed to hold a judicial post, as a Supreme Court justice or other judge, at the same time. Neither the President, the executive head of the nation, nor any member of his cabinet is allowed to combine that position with a seat in Congress. Neither the President nor any member of his cabinet is allowed to combine that position with a judicial post. No justice of the Supreme Court or any other judge is allowed to combine that judicial position with a cabinet post or a seat in Congress. The President comes to Congress every year to give the State of the Union address, but the President is not a member of Congress. That's why the Congress generally goes wild when the President arrives, with everyone wanting to shake his or her hand or even get the President's autograph, and why large numbers of normally staid legislators jump to their feet every few minutes during the President's speech. It's unthinkable that the President could be a member of Congress while serving as President, though that kind of combination is quite normal, even obligatory, in many other countries like Britain, Ireland, and Germany. But where in the U.S. Constitution does it say that the President is not allowed to combine these two positions? The only reference to this rule is the oblique prohibition that we've already referred to in Article 2, Section 1. Quote, "The President shall, at stated times, receive for his services a compensation, and he shall not receive within that period any other emolument from the United States or any of them." Does this mean that it's okay for an incumbent president to serve as a member of Congress as long as he doesn't get a paycheck for doing so? No. The same rule applies to the President's cabinet, to which the President delegates some of his executive power. Cabinet members, including the Secretary of State, the Secretary of the Treasury, and the Attorney General, are not allowed to combine that position with a seat in Congress. But why doesn't the Constitution spell out this prohibition more directly? The Philadelphia Convention that passed the Constitution recognized the need for strict separation between the three branches in their membership while retaining flexibility of function. But the Convention stopped short of putting this two-pronged rule into words, except in the oblique manner that I've already mentioned. The reason for this omission is unknown, but the rule of strict separation among the membership of the three branches has nevertheless been religiously followed at all times. Not only is it unconstitutional to hold office in more than one branch of the government at the same time, but it's also illegal under state law in many states even to run for more than one office at the same time. When Lyndon Johnson was picked as John Kennedy's vice presidential running mate in the 1960 presidential race, Johnson also ran for a third term in the U.S. Senate, just in case the Kennedy-Johnson ticket lost the election. Johnson had to get Texas law changed in order to be permitted to run for both offices at the same time, in what came to be called Lyndon's Law. Johnson actually won both elections, but he made no attempt to hold down both positions. As soon as his second term in the Senate ended on January 3, 1961, and before being inaugurated as Vice President, Johnson resigned his Senate seat, and with it his position as Senate Majority Leader. He soon regretted having to give up this powerful position because, as Vice President, he was almost totally sidelined by President Kennedy. Now let's look at the functions. Strictly speaking, the legislative branch should legislate. The executive branch should, quote, take care that the laws be faithfully executed, and the judicial branch should interpret and enforce the law through the courts, and each branch should stay away from the functions of the other two branches. But there are two problems with this theory. First of all, in practice, overlap between the functions of the three branches cannot be entirely avoided, and in some important situations, overlap is quite deliberate. Secondly, if each of the three branches kept religiously to its own specific functions and didn't stray into the preserve of the other branches, the branches couldn't act as checks and balances on one another. I'll take the first problem here and come back to the second one when we deal with checking and balancing. Some of the overlap between the three branches of government is the result of a genuine desire of one branch to help out another. For example, after Congress has passed a law, the executive branch must enforce it. Sometimes enforcing a law may involve making additional rules, but this practice has come under attack. A Supreme Court ruling in 1825 established what is called the non-delegation doctrine. Chief Justice John Marshall, in a case called Wayman v. Southard, held that important matters can't be delegated, but Congress may delegate the power to one of the other branches of government, quote, to fill up the details, unquote. For example, Congress delegates to executive agencies, such as the Food and Drug Administration and the Internal Revenue Service, the power to make detailed regulations in the areas that they cover. The U.S. Supreme Court has given its blessing to Congress's delegation of power to other government bodies. Here is the test that the court applies in deciding whether a particular delegation is kosher or not. Quote, Congress simply cannot do its job absent an ability to delegate power under broad general directives. Accordingly, this court has deemed it constitutionally sufficient if Congress clearly delineates the general policy, the public agency which is to apply it, and the boundaries of this delegated authority, unquote. The Supreme Court has only rarely struck down acts of Congress delegating power to other branches of government. An exception to this trend was the 1998 case called Clinton versus City of New York, in which the Supreme Court struck down the Line Item Veto Act of 1996, which allowed the president unilaterally to delete individual items of expenditure approved by Congress. The idea behind that act was to allow the president to cut what is called pork barrel spending, which is government spending that benefits a particular region rather than the nation as a whole. Most state governors have long had this power. President Ronald Reagan asked for a line item veto in his State of the Union address in 1986, saying, "Give me the authority to veto waste, and I'll take the responsibility. I'll make the cuts. I'll take the heat. Surprisingly, perhaps, the Line Item Veto Act of 1996 originated not with the Democratic president, Clinton, but with his Republican opponents, who had just won control of both houses of Congress in the 1994 midterm elections. President Bill Clinton then also eagerly embraced the idea of a line item veto. So what was wrong with the act? In a nutshell, the objection to the line item veto is that it allows the president to legislate, contrary to the principle of the separation of powers. Muscling in on the other branches of government. Since the United States was founded, the three branches of government have jockeyed for position, with each trying to get one over on the other branches. Here are a few examples. Legislative courts. From an early date, Congress tried to break the court's lock on litigation by setting up its own courts for certain purposes. The U.S. Supreme Court hit back by narrowly restricting the scope of the power of these legislative courts. In a case called Murray's Lessee versus Hoboken Land and Improvement Company, decided in 1856, the court ruled that a legislative court couldn't hear quite a suit at the common law or in equity or admiralty, unquote. In other words, any regular lawsuit. This left only public rights, as was referred to, determinations to the legislative courts. That is, cases between a citizen and the government. The Supreme Court strikes back. In a 1982 case called Northern Pipeline Company versus Marathon Pipeline Company, a plurality of the Supreme Court struck down an act of Congress that had set up bankruptcy courts with wide jurisdiction. The main objection to these bankruptcy courts was that they posed, quote, a serious threat that the exercise of the judicial power would be subject to incursion by other branches, unquote. Not that the Supreme Court had ever heard many bankruptcy cases anyway. Jurisdiction stripping. Article 3, Section 2 of the Constitution says, quote, the Supreme Court shall have appellate jurisdiction with such exceptions as the Congress shall make, unquote. Justice Felix Frankfurter commented, Congress need not give this court any appellate power. It may withdraw appellate jurisdiction once conferred. Was Frankfurter right? Absolutely. The Illegal Immigration Reform and Immigrant Responsibility Act of 1996 provides a good example of Congress's exercise of the power to restrict the power of the courts. Under this act, if the Immigration and Naturalization Service, INS, refuses to grant a particular person asylum, no federal court, including the High Court, is permitted to review that decision. Guantanamo Bay. Could Congress exclude the jurisdiction of the courts in regard to detention in Guantanamo Bay? The Military Commissions Act of 2006, abbreviated MCA, did just that. The MCA established special military commissions to try what were called alien, unlawful enemy combatants engaged in hostilities against the United States. In the 2008 case, Boumediene versus Bush, the U.S. Supreme Court ruled 5-4 that the MCA was unconstitutional and that foreign detainees held in Guantanamo Bay did have the right to challenge their detention in the ordinary U.S. courts. Justice Antonin Scalia, in his dissenting opinion, held that the majority's analysis produces a crazy result, as he put it. It is important to distinguish these examples of competition among the different branches of government from the checks and balances between them that the framers deliberately inserted into the Constitution to prevent concentration of power in too few hands. Now let's look at checking and balancing. Here's what James Madison said in the Federalist Papers in support of separation of powers. Quote, "The accumulation of all powers, legislative, executive, and judiciary, in the same hands, whether of one, a few, or many, and whether hereditary, self-appointed, or elective, may justly be pronounced the very definition of tyranny." Unquote. Madison and the other framers considered separation of powers essential in order to avoid what they called tyranny. But the Constitution went much further than the mere separation of powers. It also established an elaborate system of checks and balances. The concept of checks and balances is, in one sense, a natural extension of separation of powers. But in another sense, the two concepts, separation of powers and checks and balances, are actually in opposition to each other. On its own, separation of powers should just mean that each branch of government would go its own merry way without interference from any other branch. But this arrangement isn't practical because the boundaries between the three branches of government aren't clear-cut. Plus, the framers deliberately introduced overlaps between the functions of the three branches so that they could act as checks and balances on one another, keeping each branch in line. Here are the most important checks and balances built into the Constitution. Let's look first at checks on Congress, then checks on the President, and lastly, checks on the judiciary. First, checks on Congress. The President's veto power. Under Article 1, Section 7 of the Constitution, the President has the power to veto or block any bill passed by both houses of Congress. This is a really powerful tool against the legislature in the hands of the executive. Congress can override a presidential veto, but only by a two-thirds majority in both houses, which is notoriously difficult to achieve. Secondly, the veep. The Vice President is a member of the executive branch of government, but he's also President of the Senate by virtue of Article 1, Section 3 of the Constitution. But although he has the right to preside over the Senate, the Vice President is not a member of that legislative body, can't participate in debates there, and cannot vote except to break a tie. So, his potential to keep the Senate in check is very limited, especially since most VEEPs don't spend a lot of time presiding over the Senate. They tend to leave that to the President pro tem, which is President pro tempore, in other words, President from time to time of the Senate, the senior senator of the day. Judicial review. The most serious check on congressional power doesn't appear in the text of the Constitution at all, but was read into it by Chief Justice John Marshall in the famous 1803 case of Marbury versus Madison, which I'll come back to in Chapter 23. Marshall's highly controversial ruling is still accepted today. It gives the Supreme Court the power to strike down any law passed by Congress or any of the state legislatures if the court finds that law unconstitutional. I discuss the effect of this ruling later on in this chapter and also in chapter 12. Now let's turn to the main checks on the President. First, impeachment. Impeachment is the best-known check on the President because it can result in his or her removal from office.